Good morning, everyone.
Anita?
Doug, I know you can hear us, or maybe you can't, but we're going to start without being able to hear you for the time being. Okay. Good morning, everyone, and welcome to the Fort Myers Beach Local Planning Agency meeting. This is Tuesday, June 11th, 2024. Before I start anything, I'd like you all to please meet Mr. Jim Dunlap. He is our newest member. He was appointed by the council, and we're very happy to have him. I'll ask you in a minute to tell us a little bit about yourself. Sure. So if you would, please stand for the Pledge of Allegiance and the invocation.
I pledge allegiance to the flag of the United States of America, and the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Oh, so our invocation is thank you for this rain, and let it be all the rain that we're going to get this summer and not have any wind associated with rain or anything like that, and help us make great decisions today. Amen.
Amen.
Amen. There's April.
Okay, so now before we go further, Jim, tell us a little bit about yourself.
Good morning. Thank you, Anita. I'm thrilled to be here. We purchased our property in July 2021 on Egret Street here in Fort Myers Beach. We also have a home in Estero. We went through what everybody went through, and we remodeled it when we bought it, and we remodeled it after Ian. So in speaking with the mayor, during the interview process, he said to say something when you rebuilt your home twice. So appreciate having you here and the commitment to the island. I spent 38 years with a company called Huntington National Bank as a senior executive there, running many of the departments across the country, and retired now in 2017, live in Florida full time, and thrilled to be part of the process.
Yay. We're glad to have you here, Jim. Thank you very much for applying, and thank you to the council for choosing you.
Yeah.
Amy?
We need a motion and a vote.
Okay, can you guys hear us? Dawn, Doug, hear us? Yes. Can we hear you? No.
No.
Okay. Well, could I have a motion, please, to accept Doug and Dawn via Zoom because of extraordinary situations that they both have found themselves in out of town, and we hope we'll be able to hear them shortly.
I make a motion to approve the Zoom meeting with Doug and Dawn and hope to hear from them soon.
And if I may add to the record, there is a quorum present.
Right, correct.
I'll second.
Okay, we have 2 seconds and a motion. And is there any objection to that motion? Hearing none, the motion is accepted unanimously. The next item is an approval of the minutes for May 14th, 2024. If I could have a motion for them as they were distributed, or if there are any corrections.
I move to approve the minutes.
Thank you.
I'll second.
And thank you, Jane. Is there any discussion on that motion?
And
Here-
Attorney, do I need to abstain since I'm not here for the meeting these motions are relevant to?
Technically, you really should. I mean, you've had the opportunity to review it. If you had any questions about it, there's only certain items that you can abstain from voting, and I don't think that's one of
Happy
them.
to support.
Okay. Any objection to the motion? Hearing none, the motion carries unanimously. So the first item on our agenda is public comment, and this is public comment that does not have anything to do with the cases that we're hearing, or if, for example, you're short of time and you just need to tell us something that does have to do with one of these cases, we'll be glad to hear from you now. Is there anybody who'd like to make any public comment?
I have some signed up.
For the public comment?
One for EIBC and one for London Bay.
London Bay, okay. Well, London Bay isn't on the agenda, so who's here to speak about London Bay? Oh, come on up.
Mike Miller.
You popped up there like a little squirrel, Mike. Nice to see you, and
Hello, good morning,
congratulations
everyone.
for all your
Thank you.
openings. Yes, sir.
It's been a challenge.
I'm sure.
And I was up here I got a question. Is this able to be heard throughout? Everybody can hear now?
Throughout the land? Yes.
Okay. I was up at the town council meeting, and I was up here, but no one outside could hear. So I just wanted to reiterate what I was talking about regarding London Bay. They had a meeting with our canal owners about bringing a 25 to 30 people boat going down our canal. Our canal is currently 29 to 30 feet wide. They intend to, depending on season, half hour to every hour, bringing this boat up and down our canal. Let's see here. Realistically, what they're going to do, they're going to bring them to the resort through 2 other resorts, and they're going to wine them and dine them, go through their shops and have a great time, load them right back on their boat, and they go right back to their other resorts on the mainland. This does nothing to benefit. This has nothing to benefit the local businesses, only to benefit London Bay. So they're even currently promoting this at their other locations. So, I'm not here to give problems without a solution. And the solution is they get a dock at Fishtail Marina. Okay. They acquire an open air trolley or shuttle, like the one that we've got Lee has, so they don't feel confined in like a van. Okay. That canal is 90 to 130 feet wide, and it's designed to support the commercial traffic. Now let's take a look at what they've got, what the advantage is for the local community. Once all the shops and everything are back at Santini Plaza, you've got local restaurants, you've got shops, trinket shops, you've got clothing stores. Okay. They're going to know that this is there. So what'll happen is, I estimate, in my opinion, 25 to 30% of everyone that comes on that boat is going to notice this. And they're going to, let's say they're already at London Bay, and they're going to do what my wife likes to call shop out. Whenever we are, we're anywhere there's a shop nearby, I'm going to shop out before we get in the car or get on a boat and go back home. And I'll give you an example. Moms and kids, they're on their way back or even on the way to London Bay. Hey, why don't we let's do a little bit of shopping? Naturally, the dad, in my opinion, me, hey, I'm gonna hit the little sports bar and have a cocktail while you guys have fun. And then after that, let's get dinner at the local shop and maybe some ice cream, hop on the boat and go back. And by doing that, there are so many benefits to this island. They actually get to see part of the island. And best of all, there's no cars or traffic that is being implemented coming there. Versus, so what I'm saying is that the boat is a great idea. It's very, I'm estimating they could get 75 to 100 people, and that's only 25% of the people on the boat stop there. So you're looking at 75 to 100 people a day that can, if not more, that will stop at Santini Plaza. And again, no traffic, and it's a win-win for the island. And it's great for local businesses because we want local businesses to prosper. And at the end of the day, that's what it's all about, local businesses.
Thank you,
And
Mike.
if we can do that, that'd be great.
I appreciate those comments.
No problem. Thank you. Have a
very
good day.
much. It's a great idea. Anybody else?
Have Dave for EIBC, that's it.
Dave, okay, but you're going to come up. Perfect. Okay, then we'll begin our public hearings. The very first one is a vacation. Nancy, do you want to talk about the letters we have received so we can put those on record and what our processes are through this?
Yes, if I can make a few comments. First of all, I'd like to point out that you have 2, 3, 4, 5. You do have 6 public hearings this morning. I will point out that the public hearing for agenda item B is a request to review a text amendment to your land development code. And this is legislative in nature rather than quasi-judicial. The remaining items on your agenda today are the vacation, which is your first item, followed by 2 rezonings, a special exception, and a variance. So as you are aware, the land use items that are quasi-judicial in nature, this requires those public hearings to comply with procedural requirements that have been established in Florida law and in our land development code. These quasi-judicial proceedings are less formal than proceedings before a circuit court, but they are more formal than the remainder of our meeting. And we must follow basic standards of due process, requiring certain notices, application of the correct standards in our code and comprehensive plan, and decisions and recommendations made on competent and substantial evidence that is presented to you in written documents or through oral testimony. So once the oral testimony is concluded and you have had the opportunity to look at the documents in your packet, you must evaluate the testimony and the information and thereafter draw a conclusion regarding whether the criteria in your land development code or in state law has been satisfied. So pure speculation or mere opinion, not based on competent facts, you should not legally consider that in evaluating whether or not the criteria has been satisfied. Testimony by professionals, individuals who are qualified as experts before you in a particular area, that has been viewed as competent and substantial competent evidence by Florida courts, as well as testimony by neighbors and residents who have fact-based information, such as minutes, surveys, engineering reports, etc., or testimony based, again, on their personal knowledge and information. So members of the public that are present and applicants, staff, if you intend to speak, please keep this in mind. When you come forward, please state your name clearly for the record, whether or not you have been sworn in. There has been a recent change to the town's land development code regarding variance request. And in the event there is a unanimous decision by eligible voting members of the LPA to approve a variance, that decision shall constitute final agency action, which is subject to a request by anyone for an additional hearing review of the matter by the town council if the request for the additional hearing is received by the town clerk within 10 days. So when that variance item comes before the LPA, if it is a unanimous vote and no one objects within that 10-day period, that will be final agency action and there'll be no further review before the town council. So for purposes of efficiency at our meetings, we need to dispose of a few matters. First of all, I need to ask the town clerk, have all items been properly noticed?
Yes, they have.
Okay, and at this point, I need to ask if any of our LPA members have any conflict of interest under Florida law that would prohibit them from voting on any particular item on the agenda. I need to ask this question not only for compliance with Florida law, but also to ascertain if we still have a quorum present in order to proceed with the matter. So any conflicts on any agenda items today?
Let's ask the two gentlemen on the screen. Don or Doug, any conflicts?
No conflicts.
Doug?
No conflict for me.
Thank you. How about you, Jim?
None for me.
Jane?
None.
I have none. Jim?
None.
John?
Done.
No conflicts, Nancy.
Excellent. So we do have a quorum present and the acceptance of two participants remotely. At this point, we would need to swear in anyone who is intending to give testimony in the quasi-judicial matters. If you would please stand and raise your right hand, and the town clerk will administer an oath.
That includes public comment.
Yes, that includes public comment. So if you're going to speak on, on anything but the CB zoning change, you need to be sworn in. So if you would please stand.
If you want to, if you're going to speak on the CB, on the text amendment, it doesn't matter if you want to stand up and get sworn.
But if you're going to talk about Estero Island Beach Club or anything else, you need to be sworn in. Okay, I guess we just have audience
All right,
members.
we're getting some more.
Okay.
Stand up.
You know, when in doubt, just
Okay, everyone just stand up. I'll swear you all in. All right. Do you solemnly swear and affirm that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth? Okay, all parties have been sworn.
Okay, Madam Chair, your first item is the vacation. We do have copies of a resolution that has just been prepared. If you could read the title, and all members of the public would be aware of the item.
this is a resolution vacating beach access point number 42, located over real property owned by Captiva Villas at 200 Estero Boulevard, Fort Myers Beach, accepting dedication of a replacement easement to be located on real property owned by JABO LLC, subject to terms and conditions contained in the second amended and restated easement relocation view corridor agreement, replacement easement, directing the town clerk to record this resolution and replacement easement and providing an effective date. Nancy, this doesn't require any ex parte or anything like that.
We should have ex parte.
Okay. Doug, any ex parte on this particular case?
No, ma'am.
How about you, Don?
No ex parte.
John?
Should comment on it.
I drove by and physically looked at the various location.
Excellent. Jim?
No.
Jane?
Site visit only.
How about you, Jim?
None.
Site visit. Okay. Jason?
Jason, before you begin, I believe the LPA members have been in receipt of numerous emails regarding this
We have.
item. If we could, for the record, simply identify who the email was from.
Well, there's some that aren't here that were sent by emails. So the ones that we have here, one is from Christine Madden. That's the only one that's here. So I have
The one that we got by email was from Catherine Schatz.
Catherine, yes. And there was somebody else. So
Want me
Amy,
to read it,
yes, that
Phyllis?
would be great. Thank you.
Okay, bear with me because I'm going to just go down through these. Well, I have one from Catherine Schatz. Mary Herman.
That's right.
Here's one, Mary Herman again. Maura Fahey Ulrich.
Mhm.
Again from Maura. Todd Zastro.
I didn't read that one.
Would you like me to forward that one to you?
No, that's okay.
Mary Herman, Bob Basil, Christine Walters, Penny Aguirre, Jean Sicone, Phyllis Scroggy, Irish 14. Oh, Chris Fahey again, Irish 14. Marty McGinnity, Paul Doring, and Richard Rowe. That's the ones I know of.
So we need to make sure that our property owner applicant has had the opportunity to look at those emails since they have conveyed information to you. And so we'll double check. She has not. Okay, so Madam Chair, at some point, if we could just take a break
Yes, we
in the
certainly will.
process and we'll
Okay,
review those to
thank
give
you.
her the opportunity.
Jason, go ahead.
Excellent.
Thank you.
Good morning, LPA members, staff. My name is Jason Smalley. I'm with your Community Development Department. Today, we are being asked to consider the vacation and relocation of a 6-foot walking easement. The easement itself is six feet wide. They are requesting to move the easement approximately 250 feet south of where it currently exists. That abandonment would then allow for access from and directly adjacent trolley stop and funnel visitors and beachgoers through 200 Estero through what is known as the Pink Shells building across their pool deck and towards the beach. It should be noted that originally the beach access number 42, which is the access in question today, was originally approved in 1985. It's been moved a couple times in the intervening decades. Currently, a previous location for it is being used as a view corridor, a 6-foot view corridor across the property that will be maintained. So that will continue to exist if the application to move the easement is approved. One thing of note that I would bring up is that through consultations with the attorneys and the county and the town, there was an agreement that the hours of operation for this beach access would be sun up to sundown. Staff is here for any questions or concerns you may have, and I believe that the applicant is here as well to discuss this.
Who made the agreement for sun up to sundown?
This was made in conjunction with town staff. I believe the attorney was involved as well in the discussion.
This is recent.
Is that is a term of the proposed draft relocation easement?
Right.
So that is subject to review and recommendation.
And
Okay.
the previous one was not sun up to sundown, correct? It was 24/7.
Don's saying what I was going to say, but the previous easement or the existing easement, did it have a time limit?
That was not part of my notes, so I don't think I can address that. But if the applicant would be able to speak to that, she
Okay.
may have some information.
Okay. Jim, did you have a question?
So who was asking for the sun up, sundown? Which one of the staff or the applicant as it relates to those rules?
The applicant.
So this was a discussion point. I'm not exactly sure who brought the matter up initially.
Jane?
Do any of our accesses have time limits on them
Not that I'm aware of.
or lock off areas?
It would be subject to normal nuisance and land development code regulations.
Okay, the letter to Mr. Clemens from Sarah on February 21st, which is page 49 of our package.
Are you
And
talking
it
about
was-
Sarah Spector or Sarah Probst?
Gross.
Okay.
No, yeah, both of them are on there from both of them, actually. No, it's from Sarah Spector. I'm sorry.
I cannot hear Jane very well. I'm not sure if there's anything to do
Move
with
the
that.
mic closer, Jane.
Oh, sorry. It is Sarah Spector. It states that this is in the early stages, but the county staff knows now that they cannot support such a request. Can you tell me what changed to make it supported?
I think Ms. Spector can speak to that. I
Should
was
ask
not
Sarah
involved in
that
the
question.
initial meetings,
Okay.
unfortunately.
Okay.
Jim, any questions for Jason?
More towards the attorney, I guess, is thus seems vague. I've had problems in the past with the language as to, when is dawn and when is dusk versus a fixed hour. And
Personally, you've had problems with those words?
I have. So, is that something that is acceptable? And then we just saw the language for the easement this morning that got handed out. Have you signed off on that, or do we?
No, I
know
have
that-
not. It's
So
still
we
in
need to
draft
make it
form.
Subject to your approval, at least for the language.
Correct. Subject to, and that is part of the actual request, that if you recommend vacation, there has to be a replacement easement for it. And then there would be terms and conditions associated with that replacement easement. As far as the discretion that would be exercised for dusk to dawn, because of daylight savings time, it changes.
Right.
So you have to basically trust and have faith that it would be properly monitored and enforced.
And the alternative will be fixed hours.
Correct.
Hold on, let's see.
So-
John, anything? Oh, go ahead, Don.
Would it make sense to be sunrise to sunset? Just asking.
It's an alternative that you could consider, yes.
Or 1 hour after sunset, for example.
Yeah,
Exactly.
Well,
Yeah,
sunset and
sunrise
sunrise,
to-
it's a good point. Sunset and sunrise are fixed times.
Those are
versus
fixed
dawn
times.
and dusk, which are, I guess, more open, more vague.
Any other questions, John?
I actually have a question regarding the town versus the county control over those beach accesses. When I look on the website at the number of accesses that we have under control, it seems like the north end and are county accesses. Is that correct? I'm not sure.
That's my understanding, as a large portion of the northern accesses are county controlled.
They were
Okay.
probably built under
Yeah,
county.
exactly.
code
Correct.
before
Exactly.
Town incorporated.
Jane, you had another question?
Well, I just don't understand why they would want to impose these things when they are spouting that they're going to have other things for the public use at this property. Why would they shut off their dining or their, entertainment or whatever else they have? And if you get over there and watch the sunset and then they get locked out, where is their access to get back to their house across the street or whatever? I just don't see the point of, they say for safety issues.
You're going to have to ask the applicant that, Jane.
I'm overwhelmed with.
Yeah, I have a similar question,
Okay.
Jane.
You're overwhelmed with the questions.
Mhm.
Well, honey.
I'll
Okay.
get ready.
Thank you, Jason.
Thank you.
Inspector? Jane's got a lot of questions for you, but we'll let you've got answers. That's good.
I'll let you speak then.
Good morning, Sarah.
Good morning. Sarah Spector with Retzel and Andrus. I can move this. On behalf of the applicant, which is both Captiva Villas Development and JBO LLC. Would you like me to answer questions first? Or go
No,
through
do your presentation.
Okay. All right, perfect. So it's a short presentation, just a few slides since it's easier to point out what we're talking about with a map. So, no, it doesn't work. So what I'll point out here is you'll see there are 3 red outlined easement areas. The first, farthest south, is Beach Access 41. The next is the current Beach Access 42. And then the furthest north is Beach Access 43. What we are asking to relocate is Beach Access 42. Beach Access 42 will move from where you see it in the center right there, the middle red outlined area, to where it's shown in green. And as was stated previously, it will go from a bus stop through the resort, through the pool deck, and across an already established access to the beach. And this is just to show you an aerial so it's easier to see without the overlay.
Wait, go back, please.
Yes.
It looks like the proposed one goes right through the pool area too.
It does. That's what we're
That's what they're
asking.
proposing.
Okay.
And I can explain. And I think some of the comments which we may have seen back in January were in response to an earlier request. And what I'll show you is the earlier request, instead of moving it where the green is right now, is to move the 6-foot wide easement to the north and combine it with Beach Access 43. So Beach Access 43 would run between the Pink Shell and Pink Shell Vacation Villas. And that was one reason why there was some consternation among the public, because Vacation Villas did not want more traffic to go down Beach Access 43. So in response to that, that is why we're proposing to move Beach Access 42 to where it's shown in green. It's my understanding that one of the emails that you received is from Vacation Villas. The general manager, Bill Wachulis, has been working very closely with them, and the board is in agreement with the location being where it's shown in green and does support that. It's my understanding, although I don't know if you've gotten anything on the vacation, but I know with regard to the special exception, it's my understanding that there was support from Beach Villas, which is just to the south where Beach Access 41 is. So we previously had letters of opposition that I do believe have been changed into letters of support. So I know I've only seen one letter of opposition.
Well, they're complicated letters.
Okay.
Yeah.
Okay. So, because if there's anything else, I'm not aware of it and I'm not able to.
You know what, Sarah? I think you need to review these letters. So Amy,
Forward them all to her.
okay.
Okay.
So she's forwarded them all to you. Would you like to take a break and review the letters?
Do you want me to finish my presentation? And then
Yes,
I'll do
I'm
that?
just, yeah.
Yes, I would like to
Okay.
review those to be able to.
Okay.
We have been working in concert with the county because this was originally an easement in favor of the county prior to incorporation of the town.
Okay.
So we have been working with them closely. And the Director of County Lands, Robert Clemens, and the County Attorney responsible for County Lands, Mark Mora, are both in agreement with this. They have the agreements that will replace this, and all that we're waiting for is for it to be placed on an agenda before the Board of County Commissioners. I will say that we had initially suggested, just because of the nature of the location, that there be hours. It was the county that suggested from dusk till dawn, because that is what their public park hours are. So we went with dusk to dawn. We're not married to an idea, but we'd have to go back to the county and ask the county if they're okay with different hours. Because right now, the agreement that we have with them and the replacement agreement does have it from dusk till dawn. And then just the one other thing I want to point out, which I think we've discussed before, is that 800 notation there on the drawing. That's just to show you that there's only 800 feet in between beach access 41 and beach access 43. So if they weren't able to use beach access 42 because it was outside of the areas, there's two very close. And right now, the only thing across the street where you see the 800 on the bay side is all Pink Shell owned property. The only non-Pink Shell owned properties are the two you see circled. So the closest they would go to is the one on the south to beach access 41 and the one to the north to beach access 43. So with that, we believe that a replacement easement that allows for public benefit, it provides a beach trolley access, it provides restaurants and other amenities, and most importantly, what no other beach access point has, this will have bathrooms. So the public will have access to bathrooms in this location. There was a comment in one of the objection letters that the Pink Shell is not open to the public based on a previous ordinance provision. That was amended. Because I didn't see it until late in the day, I wasn't able to pull the exact ordinance, but it's my understanding in 2011, that condition was removed from the ordinance. So there's no longer a condition that the Pink Shell is only open to those guests and employees. So with that, the one other thing I did want to point out in the package, you have the easement is only to the coastal construction line, because we just figured that once you get to the beach, they had access, they were there. But the county attorney had asked that be extended to the extent of the property. So we have revised the legal description to actually go to the mean high water line rather than the coastal construction line. So as the town attorney mentioned, we are still working on the agreement. The agreement that's in there right now, I believe, still contemplates the old combination of 42 and 43. By no means is that what we plan to go forward with. We will work with the town attorney to revise the agreement. And in doing so, I do believe that staff has a copy of this. It's just the wrong one was put into the presentation. So just know that it will go to the mean high water line and not the coastal construction line. Mm-hmm. So with that, do you have any questions right now?
Jim, questions from Ms. Spector?
So as these beach accesses are normally used, you have a variety of people and accoutrements they bring with them, wagons, umbrellas, fishing poles, etc. Is there anything that you all are concerned about and or have issues with how people end up using this beach access versus the way they would traditionally use one, going through your lobby and through the deck of the pool?
No, and it's going under the building.
Okay.
So no, there are no concerns.
Okay.
The intention is that they'll be able to use it the same as any other beach
great.
access.
Thank you.
Can you go back to the other one? So this goes right into your pool area. Will they have access to the pool?
No, they will not, unless they're a guest or have a day pass.
Who will be telling them there's not a fence around the pool where this beach access comes around, correct?
One reason we do want to move this access, the main reason we want to move this access is there was an ADA issue where the current beach access is, and the pool deck had to be leveled out because there were accidents that were happening because the pool decks were not even. They've been even out, and that is one reason why the beach access cannot go through there anymore. But the one reason we've proposed this as an alternative is That's where Pink Shell staff is stationed. So they'll be able to monitor and Pink Shell guests have a bracelet that they wear to differentiate between public and
I
Yes.
see a major issue with the public going through and not being able to get in that pool because that's going to be their plan, and then having to be thrown out basically, and then to be locked off at a certain hour. I can see the benefits for you to have people go see the pool and see the amenities around, but I don't see the public benefit of going through there and being denied use and then being shut off at time in timeframes. I could not support this at all.
Okay. Jim?
One of the emails we got, and when I drove by, I thought it too, the relocated access easement goes, under the portico, past the valet, into this sort of tunnel. Like you said, it's underneath. Would the applicant consider putting some signage saying, beach access like we have elsewhere on the island? Maybe even on the post where the tram stop is, saying that the beach access is there, some sort of acknowledgement, so people know it's available.
I don't see an issue with that. Oh, no, I didn't see. Yeah, no issue with that. We could certainly do that. Right now, there is a sign for 41 and 43. 42 just for whatever reason isn't there. So we don't have an issue with that.
That's my only question.
I'm sorry, there's signage for the other ones. I was there the other day and quite frankly, I couldn't find them. Never mind use them.
Sorry, it was pre-storm. There were.
Well,
signs
I mean,
there.
is there actually access currently? Because I don't believe I tried to go down that access and wasn't able to do that.
The current 42?
Yes,
No.
there is no access.
Because of the ADA changes made to the deck and for safety reasons, it has been fenced off.
All right. Well, I also couldn't find the other two on either side. I mean, they weren't apparent to me.
And we don't have a problem with signage there either. They've been there for some time. I think those date back to.
I don't believe they're maintained or open.
You're right.
I
So-
apologize. The county handles signage, so we can work with them to have the signage reinstated.
Sarah, historically, I think those accesses have been a bit of a mystery. And for me, it is super important that they are signed just like every other beach access, because there's a lot of different nomenclature for this one. Is it an access? Is it an easement? Is it a beach access? I mean, there are different words that have been used for this. And what I really want to know is it a beach access like every other beach access on the island? Because if it is, it should have the same use. It shouldn't be any different. So I'm with Jane, and I think Jim kind of hinted at that as well. As far as the hours are concerned, it's like it either is a beach access or it isn't. If it's an easement through your property that you own and it's not public and you're only allowing certain things, then I understand the criteria for the usage. But I'm under the impression that it was nice to read all of this because I came across a name of Roxy's mother, who actually was the first person who dealt with the county for that access. And I think they should be numbered, signed beach accesses.
Which we don't have an issue with.
Which you don't have an issue with. Okay, that's great. All right. Dawn, any questions?
My question is back to the reason for vacating the old beach access.
Can you hear him? The reason for vacating.
So you made it ADA compliant now, but we've already fenced it off. So you've effectively already vacated it without town approval. Is that correct?
I would not say that. No, the access is currently blocked, but we haven't vacated it. And one thing I do want to speak to is the vacation process and maybe why it's a little confusing. This has been, as was mentioned by Mr. Smalley, it's been moved twice before. it was moved twice before by agreement with the town council. It wasn't until it was under Mr. Heron, and I don't remember exactly the year, the code was amended to provide for vacation of any type of easements, whereas the statute only requires vacation of platted easements. So it made it a little difficult to fit this round peg into, a square hole. So I apologize if there's different terminology used throughout. It is intended to be a beach access easement, and that's what we're replacing it.
Right, so
If I can just
so second
add,
question.
perhaps,
Hold on. Jacob, can you
Go
increase Don's volume? Because we can barely hear him. Don, go again.
Yeah, no, I don't want to interrupt the attorney if there was something with respect to that. I'm still very curious about the reasoning for this, meaning the ADA. Was it a step before? Is it now not a step? Could it not be rammed? I'm just trying to figure out, was it just to make the pool deck even for pink shell? And I'm just puzzled by why there still couldn't be a beach access in the same. If I'm thinking of the one which I've used before, I think in years back there was a gate there you couldn't get through, but
Right.
I'm still trying to figure out why we had to do this or why we have to vacate this. And I do think that I want to make sure that it still can be used exactly as it is today. You can take a bicycle through, all of the beach accesses, you can ride a bicycle, you can bring a wagon or what have you.
If you wouldn't mind, I'd like Mr. Wetrulis
Absolutely.
to speak to that.
Good morning, Bill Wetrulis, President, Pink Shell Beach
Morning,
Resort
Bill.
and Marina. I'm sorry?
Good morning.
Good morning. To answer the question, where the access was before 42, we had a building there. We lost it in the storm, which was the kind of the showers for our marina guests. We in turn, instead of trying to build that building up 14 feet up in the air and trying to figure out how to get people up to it, we took the building out and we've incorporated into the main building the showers and restrooms in that main building. But that landscape where that building was between the two pool decks is just completely two different elevations. We've made it, and we've had ADA issues. We've had many trips and falls in that area. So we were able to make the deck flat where anybody in a wheelchair can travel through our pool decks with full access. You had mentioned about beach accesses at the pink shell versus otherwheres. I mean, the big difference is, honestly, 18 years there, hardly anybody uses that access. We own all the land across. So if you're coming, you're either using 41, 43, or you're going to Bowditch. But we understand, I met with all the council members, the county, and here on the town in regards to this. And, obviously we would love to just take it away, but we know that we can't do that. So moving it to the best situation that it helps the public and us was what we were looking for, a compromise. As Sarah mentioned, we wanted to combine 43. My neighbors didn't like that. So we worked with the neighbors and came with this proposal where they sent letters in of support. So, we are being a good citizen with our neighbors in regards to these beach accesses. The other big one, what beach access has bathrooms?
None.
This one will. That's a biggie. It's a biggie. Trying to get bathrooms on the ground level that you don't have to go up, it's difficult. And these will have bathrooms that are accessible to anybody in the public that comes in on that access. I think it's a big one.
Can I ask you how you plan to manage the differentiation between guests and public? When I walk into your facility, you go through the valet, then you walk through the portico, then you come to I guess it's like a station where somebody is ensuring that there are guests that are allowed on the property.
It's our greeter, yeah. There's a greeter at a podium, and he's answering questions and directing people.
Or appearing to be somewhat of a hindrance if you don't feel like you're supposed to be there. My concern is that if it's not well understood by the public that they have access to that facility, as I'm walking up, I don't feel that I'm welcome if I don't believe that I belong there.
Well, and that's where I think the signage would come in handy, but that the signage isn't something that I put up. That's the county that puts those signs up for the accesses. 41 and 43 are open right now. I mean, you can go to them. I mean, they're a little overgrown on them, but those are county maintained accesses that, you know, that are not marked right now. But
Correct.
41 and 43 are open.
No, but not maintained. They're difficult to see.
Yes, I mean, yes, but the other challenge is that, you know, nobody's using those because we own all the property across the street.
I know,
and I don't mind to keep harping on that, but I just want to make it clear that, you know, the public is available to use those, but where are you going to park? You know, you're going to come down the trolley. And that's why this other location's a better spot, because the trolley stops right there. If you have trouble with walking, it's an easy access right into the property versus the other ones.
Other questions for Bill or Sarah?
And one more question. So can you tell me if you're going to have restaurants, and I assume you have a bar in there by the pool and things like that, why you would want to shut it down?
The hours, that was a recommendation with the county. My only thing is I've got to shut it down with the pool, because I can't have people coming there at 1 o'clock in the morning and falling in the pool. So, you know, there is going to have to be some hours on that aspect from a safety standpoint. But, you know, if somebody wanted to come to the beach in the middle of the night, you do have 43, you do have 41. And I mean, honestly, nobody's coming in the middle of the night to go out to the beach. But that's the only reason for the time that was, the county recommended for the dusk to dawn based on what the park hours were. But I mean, if it's sunrise, the sunset, I mean, that's fine too. I mean, we're open till 11. So, I mean, it's not, you know, if it was to 11, it's fine too. I mean, it's not an issue on our part. We just followed, you know, the recommendation of the county. We're trying to make everybody happy.
It's ended up awkward, Bill. It's just awkward to even think about it. It's awkward for me to think about, you know, Joe and Mary from Columbus who, oh, hey, the Pink Shell's got a beach access. And so they take the trolley down there. They've got their kids. They unload the trolley and they walk through your property. I'm with John. I wouldn't feel welcome. I'd feel like I shouldn't be here. You know, everybody else has got on their cute little pink bracelet, and here I am trudging through. I wonder how it's going to impact your guests.
But we get the public coming to eat at the restaurants.
True.
Many of you have
That's
been
true.
guests
Yes,
of me eating at the
absolutely.
restaurants.
Absolutely.
It's the same thing.
Okay. All right. Would you like a break to review the letters? Absolutely. Okay. So Sarah, we're gonna do the public comment, and you review the letters. And if you haven't had enough time, we'll break. Okay. Is there public comment on this? Anybody who'd like to speak on the Pink Shell? I see a hand. Were you sworn in?
I was not.
Well, come on up and you can still speak. We'll just swear you in while you're here.
Good morning. How is everybody?
Very well, thank you. All right.
Do you solemnly swear and affirm to, sorry, that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Good morning.
Good morning, everybody. My name is Melody King. I'm a local resident here on Fort Myers Beach, and I love Margaritaville. Okay. I wish I knew the Pink Shell was open to the public all this time. So thanks for that information. Rock on. Margaritaville has a beach access, and they were granted a beach access right by their swimming pool. Perhaps maybe there's a little safety gate or something you guys could put in place around the pool area, like Margaritaville did to save your guys' resort. The beach access being moved seems like it's being very personalized by the LPN. If you guys aren't comfortable with it, maybe we should make a huge announcement on the I Love Fort Myers. Spread it all over the place, and then we can all agree to help the Pink Shell. And all these things. But at the end of the day, I ask everybody to get street signs. Thank you.
Is there anybody else who'd like to speak? Anyone? Okay, we'll close the public comment. Sarah, you need a few minutes?
I do not. We had actually, as I mentioned, we did receive some opposition back in January.
Yes.
What I'm looking at now is that it was from January.
Okay.
So there is one individual, I think it's a family member of an owner in Vacation Villas, that is opposed, but for reasons that I have already addressed with regard to the resort being open to the public, us moving it, and it being codified in an agreement that we'll make sure to work with Nancy on.
Okay. Stay still for a second. Doug or Don, do you have any questions for Ms. Spector?
I do. This is Doug. Ms. Spector, do you know of any, I understand the county uses the dawn to dusk description, but do you know of any legal definition of dawn to dusk? Is there a legal definition for that?
There may be, but I'm not aware of it. I would have to look at the county
Um,
code.
There is.
Well,
There is. The pilots have it.
I think I'd like to see, like it was brought up earlier, a definition. And I think it was mentioned, they might be okay with 11 o'clock if that's the hours of their restaurant. Something like that, like half hour before sunrise to 11 p.m. or whatever. But I think you need a more definitive hours of operation.
And we're not opposed to
And the longer yeah.
So Don, Doug, they're not opposed to hours. They've been dealing with what the county suggestions or requirements have been, but they evidently are amenable to whatever hours we prescribe. And just so you know, Doug, Jim did say that there is a legal definition of dawn to dusk.
The twilight, et cetera. The pilots have to have it for certifications when to fly. So there's a definition they've all agreed to on that.
Okay. There you go. Don, any further questions?
No, I'm still, I don't support it. I'm still puzzled with respect to, I understand the explanation that it makes their pool deck better, but I don't understand why we couldn't have ramped it up and put it in the same place without any restrictions, without a concierge or greeter telling someone you can only walk through the pool deck straight through. You can't, avert your eyes or turn or sit at the pool or anything else. So I just, and I'm still puzzled why it was done before it was approved.
Mm-hmm. Okay. Don, Bill's coming back up to answer that question for you.
Okay.
Yeah. First resort reopen. 100 families from FEMA. I had to get this resort open to help this island. I had to keep it safe. I met with everybody to make sure everybody was fine. County was fine with taking it away completely. We're trying to keep it. So, I asked for this to help us because I've been helping everybody. But to get this done, I had to get it done to keep the area safe. So, if you guys deny it and the council denies it, yeah, it's going to have to go back. I get that. But I took that gamble to get the resort open. That was the most important thing for me.
Understood. Okay, may I ask, does anyone else have any questions for the staff or for the applicant?
Madam Chair, I think today we only had one expert testifying before you, and that would have been Jason Smalley, who has been considered an expert. And I'm not sure if the record is clear regarding staff's opinion on consistency with your comp plan, because that is one of the primary roles of the LPA.
Thank you. Yes, just to attest that staff believes with the relocation of the easement, since it will still be available, that it meets the intent of the comprehensive plan.
Thank you, Jason. Any further questions for the staff or the applicant? Hearing none, may I have a motion to approve or deny vacation 2024-0030 for 190 Estero Boulevard?
I move to approve the VAC 2024-0030-190 Estero Boulevard with the condition that it be subject to attorney approval of the easement language and with a recommendation to the city council to consider a more definitive timeframe, and that the council urged the county to provide 3 access signs.
I second that,
Is it
Anita.
an easement or is it a public access? I'm sorry, just a question on the motion.
Public access.
Okay, because the motion was for an easement.
You're correct. Access signage.
Okay, so there is a motion by Jim Bone and a second by Jim Dunlop. Is there any discussion on that motion?
I'd like to follow up on, I don't know if this is a change to the motion or just clarification you've already included in your intent, but the willingness of the applicant to provide significant flexibility in the hours.
Mhm.
I don't know how we build that into a condition as much as we can and influence a request, but to the degree that we represent whoever has to ultimately approve this, whether that's the county or otherwise, there are requests from the organization, LPA, et cetera, is to have a maximum number of hours allowed to be used for the public while the pool is open. The other things that we talked about, I'd like to see somehow we include some language in expressing our interest in that.
Jim, could we, would you be willing to amend the motion instead of to say more definitive time frame to something perhaps like Jim is alluding to of maximum hours or maximum usage time or something? Jim, do you have a suggestion?
Yeah, I'd like to go, if the applicant's offering the hours they're operating, I think we start there and let them walk us back on whatever restrictions they have. They can't approve that.
So the pink shell hours of operation.
Right.
Jim, do you have any objection to that?
No, we could add more definitive hours reflecting the maximum time that the pink shell is open to the public.
Okay. Do you agree with that, Jim?
I do. I support the second to that.
Okay. Very good. So we have a motion and a second. Is there any discussion? Anything from you, John?
No, I still have concerns with it. I feel it's quite restrictive. I really do.
Anything, Doug or Don?
No, ma'am.
No, thank you.
Okay. Anybody else? Any comments? Okay. We'll do a roll call vote. Jim?
Yes.
Jim?
Yes.
Doug?
Yes.
Don?
No.
Jane?
No.
John?
No.
Yes. The motion carries 4-3. Thank you all very much. I'm sorry?
Your next one.
Oh, yes, I know. It's the CB zoning district. It's very exciting. I'm sorry that, where's Sarah today? I miss seeing her.
Sarah is working on her PhD and had class requirements, unfortunately.
So darn smart. Okay, good enough. We're happy to have you and Eli here. So, okay, go ahead, Jason. This is the CB zoning district language changes. It's a text amendment. This is legislative. And so let's have a discussion.
Excellent. So good morning. My name is Jason Smalley again with your Planning and Zoning Department through Community Development. The ordinance language that's before you creates a commercial boulevard, otherwise known as CB zoning district, that allows for the uses that were allowed on those parcels prior to the creation of the CB zoning district. Under the authority of Lee County, those parcels now in the CB zoning district and were developed with a wide variety of uses. However, when the town created the CB zoning district, it chose to limit those uses, and those limitations were generally allowed or were generally focused on redevelopment of the parcels. This created a downgrading effect where once that something was developed as an office, it could never then come back and be redeveloped by right as something more intense. So it was what I like to describe as a one-way ratchet. Once you made that change, that's what you were limited to forever and a day. And any changes to that required the use of the plan development process to come back and redevelop those lots. Most changes required the commercial plan development, and so the outcome of that is that many of the lots and parcels have stayed static over the years because their uses have been limited, and any uses that were in effect after 2003 were not vested. So you have to show evidence of prior than 2003 that the use existed. Obviously, that's difficult through the county's jurisdiction over it, through the town's jurisdiction, and the record keeping was not great. So trying to establish a use existed prior to 2003 was exceedingly difficult, even if everybody knew that it was there. The town council had asked staff to recommend code changes that would allow a whole suite of uses that had been available to property owners prior to the town's development of the CB zoning district. The only changes that this will affect will be to allow additional uses. All other criteria in the section will remain the same. We ask that the LPA provide any feedback or make any recommendations to the council. I would note a couple things just to sort of nutshell this. If you look at the use table, what has been done is, with the exception of marine uses, everything has been brought to an open status. So that is much more in line with what you would see in the generally accepted full commercial zones like downtown. The things that haven't changed is you could still redevelop for a single family home, but realistically, we haven't seen much of that change from CB to a single family home. So it might be somewhat of a moot point. One thing that staff did want to bring up that didn't make its way into the memo, we did want to point out that currently the allowance for redevelopment of the buildings on these CB zoning districts are limited to 2 stories above flood if you enclose that lower area. If you leave that open or the lower area unenclosed, much like downtown, certain areas of downtown, you would be eligible to develop that second level above ground floor. So staff just wanted to put that out there and see if that was a discussion point that you would like to bring up, if you wanted to more liberalize that, or if you wanted to stick with the general feel of downtown, where certain areas are given slightly higher allowances for height and other areas are a little bit more restrictive. So our assessment is that the heights are generally in line, but it's open for discussion. If there's any questions or any concerns or clarifications for staff, I'm here to answer those.
Thank you, Jason. Dawn, do you have any questions?
No questions.
How about you, Doug?
No, ma'am.
Thank you. Jim?
No, none. I think you did a good job.
Jane? Nothing. Jim?
So the direction from the town council, was a general and not specific to the boulevard.
So we were told to look at the CB zoning district in particular because a few specific issues had arisen from that, and that some business owners in that area found it extremely difficult to do anything with the property other than continue.
But they have a remedy. They go through the CDB process.
Absolutely.
What we're doing here, though, is giving them a right to do other development, which is really expanding the uses that are allowable.
I think that's a fair assessment, correct.
Bill Veach talked about this a lot. Do you remember?
Yeah.
He talked about it a lot. And I think one of the biggest questions is that, or for me, a concern would be that density is not increased and that there's some public benefit to these changes. Those are my two, and I talked to Bill about this last night. So, I mean, those were his concerns. Those are my concerns as well.
Yeah, it's hard for staff to assess the validity of public benefit. I think we would accede that the ability for the business owners and the building owners down there to have a little bit more use other than just continuing with a office type use. The island has changed somewhat. There are
Just a little bit.
Little bit.
So the uses and what people want, especially down where the CBs are clustered down together, they may have changed. So I think that's what sort of initiated the discussion is, do we want to perpetuate the use of just offices, or do we want to more liberalize it like downtown, where you can come in with a different mix of uses that don't necessarily require that you absolutely must do a planned development to even sniff
I'll
that.
give you an example. So let's use Sea Grape Plaza because it's CB and that is part of it's very, you can visualize it, right? So Ollie's beauty parlor could only be a beauty parlor in this CB zoning. Now, it could not change to be a little restaurant, could not change to be an accountant's office, couldn't change to anything else. It is a beauty parlor. Well, wait, it could be something else that's in that plaza. Is that correct?
So just a minor clarification, they could go from a personal use, i.e. a beauty parlor, down to what is generally termed a less intense use, such as an office.
Such as an office. Okay. So that she could be a realtor or she could be a whatever,
Right.
a bookkeeper.
But
something
that's where that one-way ratchet comes in. And
Yeah.
once somebody makes that determination, then they're locked into that use as a by right use unless they came back through the PD process.
Follow up to
Absolutely.
Jim's question. Jason, you said something that resonated with me, and I'm going to make sure I both heard it right, and this is staff's belief. You said you believe that some of these lots have stagnated because of the current application of the zoning process we have, whether it's complex, expensive, whatever it happens to be. So the opposite of that belief would then be that we will see more stimulation as a result of doing this, either through ease of access or right, and more creativity with how they get used, because if they have multiple uses, they can now take advantage of them. Is that what staff believes?
I think that's a fair assessment of what could possibly happen. If nothing else, it will provide a lot more options for those current
I think that's
business
wonderful.
owners.
Thank you.
I don't have any further questions.
Like using that same plaza, the bank that was there, that could only have been a bank. They did come in and rezone. Is that correct?
At Sea Grape, you mean? Or
Sea Grape.
Well, it's outside of Sea Grape.
It's the what was the
Wells Fargo.
Wachovia, and now
Right.
it's going to be some
Casual-
coastal casual or something.
Indeed. Unfortunately, I don't know offhand. I think that change was made just prior to me getting here.
Right.
But yes, that CB zoning district could continue its use as a bank. Once they abandoned the bank use, theoretically, they had to go through a PD to do anything
Which
else.
is very expensive.
There is some definite costs in the thousands of dollars to go through the CB path or through the PD path. Excuse me.
And it takes more time.
Yes, sir.
Sure. Absolutely. So you're just looking for this kind of input from us on this, correct?
Exactly. We'd like to hear what concerns you may have about it, or see if you'd like to tweak the language. And that's why we brought up the question of the heights as well.
Well, I'll just back up and say that my concern would be not to deposit additional density, FAR, height, nothing. I wouldn't do that.
Everything from that perspective, from dimensional standards, i.e. the setbacks, heights, to your point about FAR will continue to be 1.0 in those districts with a max of 1.5 through a PD. So none of that would change. The intensification, we don't expect to increase through this. This is really just opening up the schedule of uses that's allowed in that zone.
Very good.
Yep.
Anything else from anyone? Thank you, Jason. Thank you very much. Oh, wait, that's a public hearing. Would anybody like to have any input on this? Oh, yes. Someone did. I'm glad I asked. Good morning.
Morning, how are you?
Very well. You?
Good, thank you.
Good.
TJ Grunwald from Bay Village, Vice President, Bay Village Condo Association.
Uh-huh.
So wanted to touch base on this whole situation because when it came up originally, some guy was walking down the street and asked Vice President Adderholt, hey, can we change this area? And he specifically said from Gulf Street on the water side, south, from Ascension Church, south. So based on Exhibit A, all those changes in here, it's not hardly nothing. There's a lot of strikes through here. And that would essentially make that whole area commercial use, bigger, intrusive, and everything else into our neighborhood, which is right across the street.
Oh, I know what you're talking about now. Okay.
I mean, to the best of my knowledge, there's no current owners here, landowners that are asking for this in that area because that's specifically where this was brought up for.
Well, I'm sorry, I'm not supposed to comment on this. Go ahead.
No, I get it. I mean,
Yeah.
no big deal. I'm just saying I'm only as good as what I know. So
Yeah.
that's what I know is brought up because for whatever reason. I mean, so, I don't understand why this change is being proposed now because specifically it was for that section of land in our neighborhood right across the street on the curve where the church is, allowing more commercial use in neighborhoods where houses are going up already. Now I understand like where the bank is, where the Lahaina is, and the 7-Eleven, which you can't do or anything, but or where Munchbox was. Yeah, I get it. You can't, it's commercial, build back or let somebody else, something else there. But who wants a strip mall on Gulf Street, or if you're behind Gulf Street on Estero with two houses that are brand new on both sides? Those people that are building those houses don't even realize that this is probably even going on. I have a ton of notes here. I mean, going through everything. I mean, you can see that if this goes through, it gets rid of the non-residential land use percentage that's currently on the books in your policy right now under 4-B-5. It will eliminate the summary of zoning actions on the future land map, specifically 489. If anybody looks at it, that's the London Bay, which is the Charlie's property, which goes back to what they were saying. If this goes through, that gets rid of all that language, and now they can bring whatever they want onto that property. No questions asked.
What was your name again?
TJ Grunwald.
TJ Grunwald. I'm going to have all of your questions answered. We have a policy that we're not supposed to go back and forth, but I'm going to get.
No, not a problem. So, I mean, I don't want to, and like you were saying before, Santini is right down the street. Why do we need all this new stuff? I mean, it sucks, but I mean, it is what it is. You can't get a haircut on the island anymore. No one's going to open up a shop to get a haircut. No dentist is going to come here and open up a shop unless they're bored and they want nothing to do. I mean, if it's going to get done, use the existing stuff that's there or go down to Santini and do it. But to try to create new stuff in that little section on that curve, I mean, it's hard enough. Everybody lives on this island knows you can't get out on a Sunday morning. Can you imagine adding all that more commercial use right there and everything else? So I'm just asking if you stick to the current zone or tweak what's there. But as far as hardly no changes, that's a big lie because in your Exhibit A in this packet, the first 2 pages are all strike lines through the current zoning, and it will open the door for anybody to do anything in those districts, specifically where this is brought up for. Thank you.
Thank you, TJ. Jason, I hope you're listening to all that because I'm going to be bringing something up. Patrick.
For the record, Patrick Vanass. I would implore you to move forward with some changes to the CB district. This is an issue that we've been discussing for many years. I think you've all heard the bank example. You've got a bank, they want to redevelop, they can't do anything else but a bank. And we've talked about opening up the uses. And I think just in case people are concerned about expansion or intrusion of commercial into neighborhoods, we're not changing the zoning district and the boundaries whatsoever. This is just opening up the uses. And again, if we use the example of the bank, the only way a property owner in what is a commercial district, let's not forget this, the CB districts are commercial in nature. They've always been. And again, they were there before incorporation of this town. And we restricted that because there was very little change at the time on this island. And the idea was we want to review any change that is proposed, and we want to put some stringent, we want to put a lot of scrutiny on anything that's being proposed. I think we've discussed that these things, conditions have changed, and also even uses like banks have changed. No one goes to bank anymore. You do everything online. So you have to allow some kind of neighborhood commercial use. So I'm not saying open it up to any kind of use and increase intensity by right. I'm just saying look at the uses and what is considered a neighborhood commercial use. I think that should be allowed. Anything above a neighborhood commercial use, yes, by all means, make that where they have to come in through a conditional use, special exception, or planned development. But communities like Lee County clearly define what neighborhood commercial is and what that level of intensity is. So I support staff's recommended changes. I think if there's a need to restrict those uses anymore, please do so and make those recommendations to council. Thank you.
Thank you, Patrick. I saw someone else. Yes, sir. TJ's reacting to Jim's idea about having a restaurant on Gulf Road. Mm-hmm. Good morning.
Good morning. How are we doing?
Fine. How are you?
Good. Cassius Upton, Fort Myers Beach. I have a couple concerns. My first one is everyone keeps saying that there's multiple empty lots that aren't being used. Up until the storm, the only place that really wasn't being used was that bank. There's still the medical clinic. There's real estate offices down there. Flamingo Inn was flourishing. I mean, had people all the time. So to say that there are these vacant properties seems very misconstrued because that's not true at all. Second thing is going back to before we incorporated. Well, we incorporated for a reason. Anita was our first mayor because we didn't want a bunch of diamond heads. So this is prior to that. I don't see why now that we're a town, you're going to go back and go to that. If that's the case, why are we a town in the first place? Go back to Lee County where there's actually more tax revenue and everything else. So if we're going to stay a town, which I think we should do, I don't know why we're trying to go backwards in time. Going back to Mike's point about the boat, I don't know how they already had this idea in place because without these code changes, they can't do that. You can't have a commercial vessel going down a residential canal. So just that alone will save those residents on Bahia Via and not Egret, but Curlew. So they would have less of a headache. So please just don't vote yes on this. There is a lot more due diligence that needs to be done. They are trying to change this. And the only person I see this really affecting positively is London Bay. So keep that in mind. Thank you.
Thank you, Cash. Somebody else or anybody else want to speak? Okay, Jason, I'm going to close the public comment. Jason, hop back up here because I understand, didn't even think about what you brought up, TJ. Didn't even think about it. But of course, is your neighbor. Yes. So can you address the issues? Because you remember when Jim Adderholt brought up, wouldn't it be nice to have a restaurant in this neighborhood? And he specifically talked about the end of Gulf Road. And I called him up and I said, whoa, if you opened it, people are going to, it's actually a neighborhood. I mean, granted, there are no houses there, but that was a neighborhood. And that is not at all what this is intending to do, is it?
I don't think I understand the question.
So I think the question is that the issue is that I think both Cash and TJ have just brought up is this opening up uses in only existing CB zoned properties. Does that increase or will it create the spread of some massive commercial expansion into these neighborhoods? Because if it does, well, I mean, I certainly did not see that coming.
Okay, so it's a little hypothetical here, but if you look at the opened up use categories now in CB, it's very much like downtown. So I agree in some respect that what you would see is you would be importing many of those uses from downtown into more of the transition areas. So there is always a risk of nuisance, of change of sort of the tenor of the neighborhood. But this is what we were told to do, is to come back with something that liberalizes and opens up the use for the CB zoning district owners. Now, there may be a compromise somewhere in between where we go back to the uses and expand those uses and keep the limitations with that one-way ratchet, forcing people to come through the PD process again. But I don't know if that answers sort of the intent that staff was given from town council, in particular, Mr. Adderholt. Now, there may also be a discussion of, do we want to ring fence, or is it feasible to ring fence?
What's ring fence?
So to put an overlay or some sort of specific language in the code, and staff has problems with this, but put something in the code that specifically says in these areas, we want to liberalize and bring the downtown zoning district. And on areas farther south or outside of those core areas that town council was interested in encouraging redevelopment, you could say that only these areas have the most liberalized uses, and everything else then defers back to the previous use.
What about what Patrick said about this neighborhood commercial use? I don't ever remember hearing that. Thank you, Patrick. Neighborhood commercial use. Would you say that downtown is neighborhood commercial use? Because if I lived on the south end of the island, I would not want downtown in my neighborhood. I mean, we've got a couple of guys who live on the bird streets. I'm sure they don't want downtown in their neighborhood. So
fair enough.
So would you say there is a difference? Is there some worthiness to this notion of neighborhood commercial use versus downtown open uses?
Well, I think that gets into the question of which devil is in the details, because when we say we want to sort of open up the uses, that really feels like what we brought you today. Is there a discussion where there's too many uses now, and now you want to bring it down a little bit more and focus more on specific uses you would like to encourage in those areas? But again, we get right back to the discussion of what CB was before, where we're laying out 5 or 6 uses that make sense in 2024 and saying those are the uses that we would then allow, cutting off other uses that people may have wanted. You know, do the neighborhoods really want a bunch of new restaurants down there? Maybe they do, maybe they don't. But you know, as it stands right now, you can't do that unless you've already got an existing restaurant use. So I think what staff was looking at is bringing you a wholesale change of what we were told CB, how it was problematic. And then we're just looking for y'all to sort of give us a little pushback and say, well, we want to really keep the focus on who lives down there and what sort of uses could reasonably be allowed down there that haven't been allowed down there that aren't going to exacerbate nuisances.
That's where I'd be. That's where I would be. I personally, I don't want their worst nightmare to occur. Not in any way. But I didn't think about that, and I apologize to you guys. I did not think about that. I thought about Seagrape Plaza because it's been the one that's come up over and over again.
Now,
and I didn't even think about what Jim had said that particular day.
So I wanted to make a point that whatever is going to happen with the London Bay project, they're going to be coming in under planned development. So the idea that CB would somehow give them expanded uses or something up and above what they could do under a planned development just isn't going to happen. You obviously can write your own rules when it comes to a planned development.
Yes, but there's a question about that because you know how they have said, we're not sure what we're going to do with the Charlie's property yet. It's been like this open, like, oh, but we don't know, which seems hard to believe. But so let me stop talking. New guy, you got anything on this one? Jim, I know.
There are cultures and characteristics that are unique to specific geographies across the island. And that's the beauty of both being here and being part of it and the responsibility we have to protect it. And in that context, am I hearing that there is flexibility that if we develop this particular category of zoning, that it can be overlaid in different parts and still have characteristics that are different geographically. Let's say the south end, which we both know very well, John and I, and allow those things to come in, be kickers that cannot happen in the zoning district without an additional process, hearing, and all the things you're suggesting. No problem with doing that, I assume.
I would defer to, for instance, the parking count reductions that are allowed for in downtown. They do allow for specific areas in the text.
No, that would be nightmarish.
Well, I don't
That
mean
would be
parking in general. I just mean specific areas, say between these streets are given this use. Now, I think ultimately, though, it sort of implicates a legal question about whether or not you can say we want these certain things in CB zoning district without giving it to everybody in the CB zoning district. And so I think that's a discussion from the legal perspective that we would need to sort of hash out.
So I guess the middle ground I'm looking for, certainly based on some of the feedback we're hearing, is you want to stimulate creativity, but like kind in the geographies where it has previously existed. Neighbors have become accustomed to that. Services were provided. They're vacant now for one reason or another, and this gives some additional uses that those owners or particular tenants wouldn't have had access to. But not stimulate where it didn't exist before, where it becomes intrusive to the neighborhood culture and the lifestyle those residents have become comfortable with, bought because of, and want to protect. So I'm looking for that balance where it does both. And if language is it, as long as you're not saying we can't do something that has those characteristics to it, then it's incumbent upon us to create the language to make that happen. So it doesn't have to be one size fits all. It can be laid in different geographies, and we'd accomplish both things harmoniously is what I'm hearing. Is that possible?
So what I'm hearing from you is you would like staff to answer the question of whether or not CB zoning district could be further sort of fragmented out.
I do.
Where specific areas
I do.
have an allowed use, and then other areas have either a greater or a lesser intensity, depending on what's determined the sort of
I think we
culture
get
of that
different
neighborhood
public
is.
reaction, and I think a much more supportive outcome for what we're really trying to do, and that's get these lots used, be current with 2024. You keep using the bank, and obviously know that well, but it just shouldn't apply to the places it hasn't historically been, or how we'd stimulate development that isn't consistent with the neighborhood.
It's not one size fits all.
That's it.
Right.
Understandable. Now, one thing I will bring up, because we deal with this day in and day out, is a matter of clarity. And I think that's why staff began with a very open view of CB.
I get it.
We just want to make sure that anybody reading this code also as a business owner can immediately say, well, now I know what I can do in that area, whereas before it was a bit opaque.
That's fair.
Doug, Don, do you have any input on this?
No, ma'am.
How about you, Don?
No.
Okay.
But
Thank you.
thanks.
John, Jim, anything?
I think this shows that there's an unintended consequence of overgeneralization.
Yeah.
Yeah, I agree completely with the discussion that's been going on. I think that personally, I'm very much in favor of giving people the ability to develop what makes sense for their properties, but it needs to be in conjunction with the neighborhood. I'm really intrigued by this neighborhood uses term. I don't know.
Neighborhood commercial use.
If that's a definition, I'd love to know what that is. It sounds right to me, but I don't know the definition of it.
Okay, so this is going to come back to us again.
Okay. You'd like to
Okay.
come back
Yeah.
to you again? Are you
I
going
would.
to table it? Or?
Yes,
Okay.
let's, could I have a motion to table this to not a specific date?
Yeah, before you do this,
Yeah,
can
yeah.
I would like to see the restriction lifted on properties that are just like bank uses, and, I would like the use category opened so that there's choices of things that can come back to the island that maybe we didn't have before, but maybe we had someplace else, but need to go someplace else because now there's a building or there's no building. But I think the category of bank or beauty shop, those kind of things need to have this many opportunities that can be this, and this, as opposed to just opening up downtown commercial, come in and have your way with us. We want to have, open uses for those restricted and not allow it to go down the neighborhoods, through the
Doesn't-
neighborhood.
Can I see the chart?
Over here, I have a copy.
Did you print the chart?
I did.
Yeah, thank you.
That's the way I learned, yeah.
So do you have a general concept of what sort of uses you would like to see encouraged in these zones
Well,
yet?
I mean, I can remember going to properties and pulling up what the uses could be for those properties. And there was many choices for a commercial, on Estero Boulevard property. But to take it and have it go down canals or throughout the neighborhood doesn't seem like the neighborly thing to do. But I think that we need to open them up so that we just don't have spots that nobody's going to fill, because banks are probably not coming back here other than maybe an ATM in a hotel. I just don't want our labels that we have put on these uses to create non-developable
Developable.
properties.
So let me kind of take a step back here and just state, remember at some point in the past, 2003, there was a series of uses that were thought to be good at that time. And over the years,
In 2003?
I believe that's when 2003 was the stop date when if you didn't have that use existing,
Oh, yes, okay.
you no longer could continue that use without a PD. So
Okay.
I apologize. But the point being is somebody kind of already went down that route is what it looks like. And we ended up with 4 or 5 uses that everybody thought was great in that area. And times have changed, the culture has changed. So I'm making the point that if we go back and say, well, instead of 4 uses, we really want 6 uses down there. What's to say we're not going to be down here in a few more years with business owners saying, well, those 6 uses were great, back in the heydays of 2024, but now the market dictates that I have to do something better or more intense on that property, or a different type of use that wasn't envisioned today. So I just think it's not an answer to just say we want to add a couple more uses to it. The language change needs to be a bit more holistic, but we will take the suggestions that we've heard today and we will attempt to refine it for the next time that this comes before you, and see if that meets what your intentions are.
So I'd suggest, I guess, a distinction with the difference for me is this context matters a lot. There's a point in time where the island was, as someone suggested earlier, was completely built out. So the stimulation wasn't there for uses to appear in neighborhoods and in areas of our community that no one thought ever would, because you couldn't get rid of what we had and it was what it was. It's a whole different environment right now. I'm not really as concerned about what would happen several years in advance. The LPA or council could deal with that at the time. I'm concerned about making sure that the next series of decisions get made in this very vulnerable time are consistent with what we want them to be.
Correct.
After they're put in place.
Okay.
And that's why this is so important and delicate and nuanced. And I think in that regard, I'm willing to make a motion to table this, the language on the ZB zoning district, and until such a time we get a chance for both provide more input to you and come back with some alternatives that are not absolutely consistent across the entire island.
Okay. I second that motion.
Thank you, gentlemen. Is there any discussion on the motion? All those in favor say aye.
Aye.
By the way, the definition of neighborhood commercial means a commercial use such as a small grocery, general or specialty stores which furnish convenience goods and services to meet the daily needs of the residents of the neighborhood.
That sounds about perfect.
So it's a very nice definition. Okay, thank you. Thank you very much for being here today.
Thank you.
Okay. The next item on our agenda, does anybody wish to take a quick break? No, everybody good? Okay. Next item on the agenda is DCI 202-40015. This is 186 and 1840 Estero Boulevard. This is an ordinance of the town of Fort Myers Beach, Florida, approving approving with conditions or denying a Town of Fort Myers Beach ordinance, and approving the conditions for the commercial plan development rezoning for the properties located at 1836 and 1840 Estero Boulevard, less the area within the environmentally critical zoning district, generally identified as strap numbers 19-46-24-W4-03200-00CE and 19-46-24-W4-03200.1010. Fort Myers Beach, providing for other clarifications as necessary, providing for conflicts of law, scrivener's errors, severability, and providing for an effective date. May I ask, does anybody have ex parte communications to report? How about you, Doug?
No.
Don?
No.
Jim?
No.
Jane?
No.
Jim?
No.
John?
No.
And I have none as well. Nancy, you have anything you need to say here before we move forward?
No.
Okay. Jason.
Good morning. Jason Smalley again with your Planning and Zoning Department. As was mentioned in the introduction, this is a request for a rezoning into a CPD or commercial plan development for the lot located at 1836 and 1840 Estero Boulevard. The proposal is to redevelop a timeshare condominium of 75 units. Those 75 units existed prior to the storm, so they're requesting to continue that use at that intensity. What they are asking for is 5 separate deviations to make the project feasible from their perspective. The deviations include additional height. They are asking for 47 additional feet above the 40 feet that would be allowed in that zoning district by right. They are asking for relief of the requirements to screen parking areas underneath the building. They are asking for relief from the requirements that the building provide entrances facing Estero Boulevard. And in that same vein, also asking for relief that the building provide entrances and frontage doors and windows at minimum 50-foot intervals. Lastly, they are requesting a deviation to remove the calculation of the lowest floor from the floor area ratio calculation. Reminder that the town does include that lower area if it is taller than 6 feet above grade in the FAR floor area calculations. In the request, there's a separate alternative ask for 5 that if the deviation to remove that lower area on the ground floor is not approved, they're going to have to request an increase of the FAR from the allowable 1.4 to 1.67 to make the development feasible the way that it has been designed. So the building itself has been in existence for many years. It was originally developed in 1981 as a multi-unit timeshare. Portions of the building and portions of their pool and pool deck were developed seaward of the 1978 CCCL. That has been recognized in discussions with staff, and both us and the applicant understand that at some point in the future, they're going to have to come in to discuss how and what their design for those pool areas are going to look like. But the intent of this process is to pull the buildings forward towards Estero, away from the 1978 CCCL line, which a portion of one of their previous building, the northernmost building, went across that line. Staff is here for any questions or concerns that you may have, and the applicant and the applicant's representative, Mr. Droblik, are here for questions if you have some for them.
Thank you very much. Questions for Jason? John?
None at this time.
How about you, Don?
No.
Doug? Doug, do you have any questions?
Not at this time.
Okay, Jim?
I'll defer till after we hear from the applicant.
Thank you. Same, Jane?
Same with me.
Same with you. Okay. Thank you very much, Jason. Could we ask the applicant to come forward?
You'll see Fred in a minute, but I'm going to introduce the, here it is. Okay, perfect. Okay. Good morning, Sarah Spector again with Retzel and Andrus. I'm here on behalf of the Estero Island Beach Club Condominium Association. We do have the team here today. We have the vice president and manager of the association. I am here. Fred will be here to speak on behalf of the planning aspect, and we do have the engineers here in case there's any engineering questions.
Sarah, did you want them to be qualified as experts?
Yes, ma'am. Thank you.
Could you state for the board or for the LPA their qualifications, or
Can they do that when they come up?
yes,
individually?
that'd be fine. Thank
Okay.
you.
Thank you very much. As Mr. Smalley said, we are asking for approval to rezone a downtown zoned property to commercial plan development. This is one of the only residential-ish. We understand that timeshares are commercial within the code, but the residential-ish development in the downtown development area. And so we are asking for a rezone to commercial plan development, rezoning only a portion of the site. As I think Mr. Smalley also alluded to, the site is 2.7 acres, but we're only rezoning 1.92. The remainder of the property is in the EC zone, and we're leaving that as is. If anything does need to be done in the EC zone, such as repairs to the pool that is currently located there, we will come back for a special exception. But currently, we're not asking for anything within the EC zone. So the purpose of this request is to allow the timeshare to build back the same number of units that they had before. As Mr. Dravlik will further expound upon, the reason that we are asking for 7 floors over parking, so for a total of 8 floors, is the orientation of the building. This was, the orientation was discussed with town staff, and we understood that one of the points that the town council is looking for, and the LPA as well, was the view corridor. And we wanted to reestablish a view corridor because the way that the buildings were situated previously, which we will show you, did not provide much of a view corridor. So we're reestablishing a view corridor, but only building back the 75 units that were there before. With the 7 stories over parking, it's a maximum height of 91 feet over the base flood elevation +1 and 87 feet from the design flood elevation established by DEP. And as Mr. Smalley mentioned, we are asking for a deviation to exclude the first floor of parking for purposes of calculating the floor area ratio. For purposes of identifying where this is, you all are probably quite familiar with it because you looked over the property when the building, when your meetings were in the Diamond Head.
It was very sad.
It was very sad. It's cleaned up now. It's a clean site, and we're looking forward to building back. As you can see here, it was developed in 2 separate buildings. And I'm sure there's pictures later on, but they were perpendicular to the Estero Boulevard, and we're looking to build that back with a slight L turn towards Estero on the larger of the buildings, which we'll show you when we show you the master concept plan. And Mr. Smalley already shared this with you, but just in the way of a quick background of the buildings, they were constructed in 1981 prior to incorporation of the town. There was 2 buildings. One was 3 stories, one was 2. And there were 2 pool areas. One is remaining that crosses over the EC zone, but nothing is planned other than to open that back up if possible. At present, the site is vacant because the buildings were in such a condition that they needed to be demolished. And the intent with the demolition was to be able to build back what was there previously. As we've had several meetings with the timeshare owners. There's actually quite a bit of participation, and they're very excited to get back in their building. So they do want to see this built back. So in order to accomplish that, we are asking for the commercial plan development to allow for the 75 units to be built in a 7-story overparking building. So with that, I will bring Fred up here. Fred Drovlik is the planner, and I would ask that he be admitted as an expert. So I would ask that he share his qualifications with you.
He already has been.
I'm sorry, you're right.
That's
So
okay.
yes,
Okay. So
but
we're
if
good.
we do need the engineers, they will need to be certified.
Thank you, Sarah.
Yes.
Good morning, Fred.
Good morning. And once again, thank you everybody for their time and their efforts on this important. Well, your role is very important, so we appreciate your energy. I'll try not to be too redundant. I do have a number of slides, so I want to hit on the details. Hopefully, it takes care of most of the questions, and we can get to the real meat of what you're concerned about on this project. So I provided a couple of kind of walkarounds of the property historically, and to show the things that we had to think through. So on the left picture, we're showing the existing pool. It is over the CCCL line. The majority of it on the master concept plan, we show where that goes. The pool equipment was landward of that line, but the pool structure itself, the majority of it is across that line, as was the building closest to Diamond Head and Palm Avenue. There were about 10 units that were over the coastal construction line, which will be rectified. The beach view, so to speak, on that side was really, there wasn't a whole lot. I mean, the buildings weren't real tall, so there was sky above, but in order to see through to the beach, you really just had the drive aisle in between the two buildings. And I have some other pictures of that. For the most part, then there were the buildings on each side that obscured the rest of the view. So maybe it was 50 or 60 feet in between there and the drive aisles. On the right picture on the right, we're showing a couple of important things. One is all the parking spaces that were backing out directly onto Palm Avenue. Obviously, it doesn't meet code now. We're going to fix that. We'll show you the master concept plan. That'll make that beach access safer and just modern. The building on the right, along Miramar Avenue, was the taller of the buildings. It was, and that road is a little more residential. So part of our design was to go up, but then to move the building away from the residences and closer to Diamond Head, where it was more compatible. And then the other two things to point out there was that there were two entrances onto Estero Boulevard, and those will both be eliminated with the redesign, with entrances only being on Miramar and Palm, and a decent way down, so there's no traffic back up on the turns. So I'll show you that here a little bit. Next picture is a few more historical pictures. I'm sure you're very familiar with these, but Google Street View still shows the historical pictures. In the upper left is Palm Avenue showing Diamond Head, the existing building, and the pullouts of the parking spaces onto Palm Avenue. The building location there will be similar to the proposed new building. So it will be, the boundary will be along Palm Avenue. Estero entrance by Palm Avenue. So that's showing one of the curb cuts that are there that are now going to be eliminated. It was fairly close to Palm Avenue. And corner at Estero Boulevard and Miramar. I put that one on there because, you can see the parking was almost right up against the sidewalk. The parking went clear to the corner. The way we're going to redesign it, and based on current code, in order to meet codes, there'll be more area there that'll allow for some landscaping and some other things. And I think that corner will be beautified to a decent extent. And then just general in the bottom views from Estero Boulevard to the beach. You can see on the right-hand side of that picture, there's the view corridors down the drive aisle that was also a curb cut onto Estero. So now let's go to the next page here. Of course, the zoning as existing is the downtown district, and we're rezoning it to commercial plan development because of the increased floor area and the height, and the number of deviations that we'll run through. Obviously, all new construction will be landward of the 1978 CCCL line. In the subject party future land use category will remain the same. So in pedestrian commercial, I put this map on here just as a matter of completion of the zoning and entitlements, but we are not making any changes to the future land use category. The green is the rec line, which is corresponds with the CCCL line, and then the other part is the current zoning that'll be changed to CPD. Let's walk around the master concept plan. So let me start in the upper left-hand corner. This Astero Boulevard is on the top of this page. So Astero Boulevard on the top. Then you have the redesigned parking area in that corner. From the corner of that property to the closest piece of the new L-shaped building, there's about 170 feet. So that would just be landscaped area that you would be able to see straight through. We are proposing buffers surrounding the property. It's not required in the zoning district, but we've left 5 feet surrounding the property and to do a type A buffer around the perimeter, all except, of course, the boundary line on the CCCL. We moved the entrances now are quite a bit south in there, partly to be able to for people to pull off Astero Boulevard and not have somebody else there, pulling into the parking space slowly and creating traffic conflicts. So on Palm Avenue and Miramar, those are the sole entrances now to the property. The L-shaped building in the gray is, on Astero and on Palm Avenue, understory parking. We have 83 spaces here proposed. The district allows for a pretty substantial reduction in parking. There was 87 prior. We're proposing 83. We actually do have room for probably a few more. This is a conceptual plan, and we'll redesign that. So we aren't the parking. I don't think will be exacerbated. It'll be either close to or the same as it was. So then what I'll go through right after this is then the advantages of going higher. I mean, I know height has an issue or some issues, of course, with compatibility. In this case, height has several benefits that I'll run through that I think are advantageous to the site plan and hopefully the redevelopment of this in the long term. Let's see. Let's go to the next one. So we provided some elevations. This one would be looking from Astero Boulevard. It's a little hard to see the turn of the building there based on the angle, but what we do show is to the right of that building, that kind of view corridor. So that would be the landscaping and overlooking the new parking area. And then the building we propose to have with no screening underneath so you could see through. I think the design flood elevation there would put our lowest beam, I think, at 20 feet. So above cars there, if we don't have screening on that, we would have, a substantial amount of light to be able to see through there, which was kind of the idea here to make it seem lighter, even though it is taller. So to reduce the feeling of mass on the building.
I hope those are not waves that you put. They don't have mountains, so I can't figure out what they are.
I guess artistic freedoms on some of that there you could see the Gulf waves that were, rolling up 5 feet high. That's pretty funny. Yeah, that's a little higher than normal surf that we have, isn't it?
Let's wipe those out.
Yeah, that's funny. Yeah, you're right though.
There you go.
Yeah, they're gone now.
Job.
Yeah. So, and the reason why now we're looking from Palm, so this would be with our back at against Diamond Head, looking, I guess, kind of north from Palm Avenue across Astero Boulevard. Then would be on your right, and that gives some idea. That's to scale of cars underneath the parking, what you could see through there. And then on there are obviously the elevations, as was stated, we're 87 feet above the design flood elevation for FEMA, which is higher than the base flood elevation. There were 91 feet above base flood on this. So additional 47 feet. We're allowed 40 feet above base flood in this district, and we would be at 87 technically. So the difference is 47 feet above what is permitted in this district without a CPD. The next one slide, so benefit of increased height. So reduced lot coverage, obviously, if you're putting two buildings into one, you're going up, you're going to have less lot coverage. So our lot coverage is significantly less, which allowed us to then increase the view shed in order to see through to the Gulf. Under building parking, lighten view through the under building parking as well, which is one of our deviation requests for not having it screened in as a commercial building on the ground floor. Compatibility, so we're able to move the buildings towards Diamond Head against Palm Avenue, move them away from Miramar. Unit counts remain the same, still 75 units. That part of the post-disaster build back. And parking provided is above code and close to what existed prior, and they didn't have any parking issues prior that me or anybody else here is aware of from the group. So sustainability, obviously, is building to the moving the 10 units in the building away from the CCCL. So no units are proposed beyond the 1798 CCCL. So this is
Back in time.
Back in the day.
Yeah, back in what a day. The pioneers established that. So no, that's my typo. Redevelopment of the property exceed the current Florida building codes, obviously, in the FEMA standards. All right, a few more slides. Oh, there we go. Deviations. So first one, obviously, is the height. Allow 40 feet and 3 stories. It will be 8 stories and a total of 106 feet from the ground, 87 feet from design flood elevation. So the number 2 requires hotel buildings without commercial area or uses below base flood elevation to screen under the building. So we're asking to consider that as a deviation to allow light and air through and be able to see through to the Gulf and lessen the mass of the building in the field. Requires the deviations 3 and 4 require entrances and views into the first floor of the commercial building. So timeshares are considered commercial, but obviously it's a fully residential building. There's no storefronts or anything else that would require pedestrian access on the ground floor. So we're asking that requirement be deviated from. And then ground floor parking included in the gross floor area. That was the deviation that Jason outlined well, that if we are granted that deviation, we meet the floor area ratio for this district at 1.4. Almost done here. So there's a couple of LDC compliances. I really want to sum this up and say that there was some analysis in there and some wording that maybe I wouldn't use that Jason used, but for the most part, when he came to the findings and conclusions, we are in full agreement with the staff report as it is written. The recommendations for the deviations, findings, and conclusions, the meeting of the criteria for plan developments, the 3485B and C and 34216-2 set forth the requirements for considerations and findings and approval of zoning. He states that we meet all 12. We agree that we do. And then I highlighted a couple there about densities, intensities, and general uses. Obviously, I think this fits. So we agree with staff. So I'm not going to belabor these too long. Same with this stuff, the compliance and consistency with the comp plan. We believe this is consistent with the building height request under 4C-4, where we're allowed to do this based on a CPD request and the other considerations that we made for the site design. And so in conclusion, again, we agree with staff recommendations, conditions, and their evaluation. And we don't believe the proposed development it doesn't increase units or trips from the site. It allows some additional benefits with views, lower building away from lower intensity uses, curb cuts on a stair, improves buffers, and increases resiliency, obviously, based on the new build. So in my opinion, as an AFCP certified planner, I agree and would ask for you to recommend approval on this. And it's exciting for the residents. I know you are all even more familiar with me, even though I have a timeshare here on the beach as well. Luckily, that place is actually opened as of last week with the tropical sands down on the south end So I'm one of the few lucky ones that gets to go back in. So, and my assessment wasn't that bad. Great management. And John Shaw is one of the people that manages this as well. And he's one of the people that really worked through that to have the assessments not be onerous and really have people just stop paying, and bow out. So I really appreciate their efforts to get the ownership on board. I mean, it's going to be expensive. There's going to be assessment. So we're trying to balance all those things and try to make the best development we can out of this and have this be back up and successful running timeshare. There you go.
Thank you, Fred. Questions for the applicant, John?
I have some.
Oh, okay, Doug, you start.
There's a lot of good thoughts in what was presented. I guess what I'm challenged by is the elevated mass right on Estero Boulevard. And other proposals for height variances have had a more inventive architectural design where there's like the building stepped back or otherwise adjusted architecturally so it's not such a mass that you're looking at here. For example, even Diamond Head next door, is sort of set back from Estero. As this face here, this elevation that we're looking at is right smack on Estero Boulevard. As close, pretty much as close as you can get it, which I appreciate because they have the view corridor and they have the landscaping and they have the view under the building. But still, I think it's, frankly, I hate to be so blunt, but I think it's going to be kind of an eyesore the way it's presented. And it's such a big mass vertically right there on Estero Boulevard. And I'd like to see a little more creativity in the architecture.
Thank you, Doug.
So that's my comment.
Don, anything?
I would echo Doug's comments. That's my only reaction. Again, I love that folks are building back and excited to see it. Just that was my reaction to it. Is it just seemed kind of with the height right on Estero, it definitely. But I do love that they went from 2 buildings to 1 and did some really creative or good things with respect to ingress, egress, and those things on the property. So they definitely very thoughtful. Just that was my only thought.
How about you, Jim? Any comments?
No, it's been covered nicely. I agree with what both gentlemen said.
Jane?
A couple, I would just like to,
She does it all the time. Thank you, Jim.
I would like to know the difference in the size of the units and what the height of ceiling is on each floor.
Okay. What's that? Yeah, come on up. Have our engineer come up. I can guess, but I don't want to. And on the elevation, it does show that. So but we'll have the expert have.
We couldn't really read it on our teeny tiny little piece of information.
Well, first, we need to qualify you as an expert. So could you give us your qualifications and your name, sir?
My name is Robert Hoff. I have engineering education from Northwestern, legal education from Pepperdine. I've worked for 2 different engineering firms over a course of probably about 5-10 years, right in that range.
Bravo. Could I have a motion to accept the gentleman as an expert?
So moved.
Second.
Is there any objection?
Nope.
Okay. You're an expert.
On a bunch of things, I hope. I didn't hear your question. I'm sorry.
My question was, can you tell me the difference in the square footage of the units and the height of the ceilings?
Ceilings, I believe, are the same.
Really?
Yeah.
Built in 1981?
If they're not the same, they're in the current code, whatever the current code required. If there's a difference from that, I didn't pay much attention to the height, but the footprint I can speak to.
Okay.
There is a size increase, but the motivation behind the size increase, been working with Jason to try to minimize the amount of variances we'd have to come and ask you for. We needed to bring these units to ADA compliance. They were not ADA compliant before. So the essential additional square footage interior living space was based on having that ADA compliance where wheelchairs spinning, being able to eat in the kitchen, bathrooms, and all of that. Specific numbers, I can get that to you. I just don't have that with me right now.
Okay, can you get that to me in this meeting?
Maybe, but most certainly I can get it to you by the end of the day.
What?
My associate's working on it.
Okay.
He's
okay.
got his phone, and we're trying to email the home office to see if I can get those calculations.
Okay. So I don't know who to answer this next question of, when you're asking for no relief of screening underneath, what will be underneath that people would want screening from? So where's your trash and all that kind of stuff?
Well, the trash, I can show you, it's on the footprint there. There's a designated area that would be walled. There is a zoning requirement that has it enclosed. Presently,
Yeah, it's on. Yeah.
So at the back of the property.
back to the property.
The
End of the
dumpster.
parking area is kind of close to Miramar.
And those things will be screened.
Those things will be
Being
screened,
closed,
yeah.
actually.
Underneath is just parking and a little bit of
All open.
you know, the elevator.
The elevator and
that kind of
entrance,
stuff.
okay.
Underneath is nothing else. So we're asking relief from the screening so you can just see through.
The main motivation for that was view corridor. This property has a long history. Jason and I spent a lot of time talking about this along with Sarah Probst and others. One recurring topic that we just couldn't ever get away from was the importance of this view corridor. And so in order to try to show good faith, best effort possible, not just to the building department, but to the city and the citizens around, was to say, how much can we possibly give you see-through access? At the end of the day, you're going to have cars and modernly SUVs. And so there is going to be limitations, but to the extent that we can provide a view corridor, we want to. Now, on the flip side, maybe the turtle people don't want the light coming the other direction. We're open on that. This was primarily a give back to the city.
Also, you know, the building is very plain and a big box. I hope that you will have some architectural things on the painting or something of this building so that it is more than just a.
This is an engineered representative. We work in black and white and ones and zeros. The architects are the people that color the world. And once we get the pathway to an actual building, I assure you our intention is not an eyesore, but to create a signature property for the island.
Okay.
Anything else, Jane?
No, not until they can get that.
Okay.
Number.
Jim, anything from you?
Couple of things have already been said. I was interested in finding out what the size of the units was. The setback from a stereo is, I think, counterproductive to what we've been saying is, especially the taller buildings, you know, push them back from a stereo, not bring them up to a stereo.
Mm.
And as far as deviation number 2, if you're parking cars underneath the building, you've already blocked a certain height of the view corridor. So I'm not sure, I don't see why plantings that have a maturity that's no higher than a car can't be planted along a stereo, because it really, you've already got some view obstructions there. So those are my comments.
John?
Yeah, I think the right questions have been asked already. I understand you're looking to build the envelope at which you can build in, and the giving it single story is, I think, preferable in this case, or single unit building. I have the same issues around massing and architectural design. It feels like it will be, at least from the rendering, kind of a monolithic building. A lot can be done with landscaping, a lot can be done with architectural details. We're not seeing it. We're seeing it pushed, as has been stated, directly against a stereo.
Yeah, part of that with the, sorry.
No.
Part of that with the up to Estero is that district has a build 2 line.
Yeah.
So it'd be additional deviation.
That's another variation, because you're supposed to be 5 feet from Estero.
Yeah. So it's,
But that's
put it
really,
where
That would have been a
that's-
deviation worth asking for.
but that would be a deviation really for storefront things, right? This is not that use.
Right.
Right.
right. It is, you're correct. Yeah. The build 2 line, I don't think applies to this as much, but yeah, that would be a deviation.
You know, Fred, when the town had this Christmas tree festival last year, I met 2 sisters who are owners at this place, and they were just lovely people. And I wish I had asked them for their phone number, because I would have loved to have talked to them about this, because the last thing in the world I want to do is stand in the way of them. I mean, they've had this property in their family, their grandparents, their parents, now them and their children. It's a generational thing, which is very typical of Fort Myers Beach. And over the years, I've known lots of people who have, been part of this property. But this particular plan is just, let me just do an aside here and ask Nancy something. Nancy, there is lots of chatter about this on social media, and I read quite a good bit of it. Would that be an ex parte?
It would be, and you
Okay.
should disclose what information you have retained having read those social media posts.
So I will disclose that the chatter or the commentary had to do with the height, which, for many years now, I've been, using a piece of paper and saying, do we want this box or do we want this box? In which case we have space. And I can make an argument for this box versus taking up the whole property. But I can't make an argument for something that the commentary was in large part due to the massing on Estero Boulevard, which I don't even think that everybody recognized, because until you just pointed it out, I didn't recognize it was up on Estero Boulevard. But it was a lot of commentary about the look of the building. In a case we just had, there was also commentary on the look of the building, and I think in part it's why it passed. Because there's something about, I was having a conversation with someone yesterday, and there is so much to be said about the public realm, the public space, how people experience Fort Myers Beach. And if sir, this is meant to be an iconic or a wonderful contribution to our rebuilding of Fort Myers Beach, you haven't hit it yet. And I think that perhaps more than anything is impacting my decision on this today. Doug and all these other gentlemen have all said, you're taking this high building and you're putting it right on the boulevard. It's a bad idea. It's a really bad idea. I'm not a planner. But I'm a good visual person. And it just seems to me that there would be some other way to present this project so that it was more amenable to those of us who won't be staying there, and those of us who every single day will be experiencing the boulevard. So Fred, and if the 2 sisters are listening to me right now, please know that I want you to have this. I can't support what I'm seeing here today. And it's unfortunate. Maybe this application isn't ripe for the process right now. Maybe this would be better to be, instead of denied, to be continued, so that we can see a further or a better explanation of what this property will look like and how it will impact the neighbors, the boulevard, the community. So I'm going to leave that with you to think about for a moment. Everybody's made their comments. I'd like to open this to.
He's coming back with an answer.
Oh, he's coming back to an answer for Jane. Okay.
I have your information. So we do have 10-foot ceilings as part of our concept plan here. The interior square footage went from average of 625. There were different floor plans for the different 2 buildings. So obviously that's now uniform, and it's 850. So there is an increase.
But minimal.
But like I said, it's largely attributable to ADA compliance. And I agree with you. My takeaways from listening to you is, first of all, it's time for us definitely to engage the architectural side to this to beautify it for you is what I'm hearing a lot of, but also to come up with a design that maybe takes it off of Estero Boulevard.
That's right. That's right.
But it sounds to me like if we can make it look pretty, make it look like something you want to see, come back with another variance request to take it off of Estero, the concept of going up higher is not a big problem for you folks as a board. Is that a fair takeaway?
Well, I think that the thing I have to also disclose that I did read the posts that were on Facebook, and most of it was on height, but I do think the general public may not truly understand that they have a right to the 75 units, and you have to give some extra space for making them ADA compliant in today's building structures. So they are going to be a little bit bigger, not a huge bit. That's why I asked that thing. And their floors are not 12-foot or 14-foot floors. They are 10-foot, which is very reasonable. And in allowing for the view corridor, it is a choice that we can either recommend or not recommend, but it is also a way to get view, light, air moving through, and it does benefit the people on the other side of the street. Instead of having a concrete building that goes from corner to corner of concrete wall, which is not what we want in our houses nor in our commercial, that it is something that we need to educate the public on. This is a choice in how we can rebuild, either to go with it this way or this way. And so I do just want to kind of educate there. I know that's not really a question, but
I think the comment you're talking on is it was repeated over and over and over again. Follow the code, follow the code. Well, you are in fact following the code,
yeah,
because you are going through this process. There is this process that is available to any property owner, any resident, any commercial process. You have the ability to ask for something that is outside the box. And then it's our option to say yes or no. So you're right, Jane. It's difficult to understand.
To take one unit off the Palm Street side, flip it onto the Estero side building, and that would give us one unit pushback. But as you point out, that's the flip the paper sacrifice there. That's going to remove whatever the width of a unit is from that view corridor that we're trying to be as open as we can.
But it might give more air feeling than it being right there 10 feet in.
I think that's, and I'll discuss with ownership, I think that's what we will do, start with that. And then, like I said, we have an architectural team in the wings waiting to get onto this. And it just hasn't been the right time. We so thought we were wrong. So we will come back with a better appearing design, aesthetically speaking, and probably spend a little bit more attention to the landscaping component of the drawings too, just to give you a better feel for what it would look like. Because the ownership truly does want to make this a property that the beach is proud to have.
Well, of course they do. Yeah. I mean, of course they do. There's so many people here who have, lifetimes invested in that property, and we understand that. But it's, I hear a lot of conversation back here. Is there anything that we should know?
Sure. Yeah. Excuse me. My name is John Shaw, and I'm principal in this construction management of the property.
Yes, sir.
We
hear you've been doing a good job.
Well, we're trying our best.
Good.
All right. This design was due to the requirements that the city requested of us, not our design. We came in with a 3-story design, which would have taken up much more space within the property. The clear view was a major issue. The design change was done due to that. The architectural part of this has not even been done because, again, we were more or less turned down on our original request. Okay, so this was really nothing more than that. If this is only, my biggest problem is, again, time. We're already 2 years into this almost.
Mm-hmm.
We are losing people all the time. More and more people are dropping out of the situation. The longer this takes, the more likely that maybe it will never be built. this is again one of those things that I understand. Looking at this drawing, we don't have architecturally design involved with it. I mean, again, what would make the city happy? That is what we want.
Well, first of all, it's a town, but that's just the
Yes,
stickiest
okay.
thing. But Mr. Shaw, are you telling me that you came forward with a plan for a 3-story building and you were told don't build this?
Yes.
We need more talk with you.
Again, so this did not meet the criterias of the city or the town that would give us. I thought we had all of the parking, all that involved with this, but the clear view was an issue. It took up a different design. The parking entrances needed to be adjusted, which we could have done. But it still would have been parking underneath. It still would have had.
Let me see let's hear what Jason has to say to this.
So yes, if you'll remember back when we were all working out of Diamond Head, I believe this came up, and I believe it was Councilor King who had a lot of discussion about this. Staff, when we read the code, it was very explicit. The intent of redevelopment of this area was meant to provide these breaks, and as big a break as we possibly could for all the reasons that people want view sheds. So when we were brought a review, an initial design, and they've gone through multiple designs now in conjunction with us, it was a lot like what existed before. There was 2 buildings. There was effectively a little sliver of light coming above cars and below the building itself. And the argument at that point, or let me restate that, the discussion at that point was more about, well, doesn't that really answer the view shed that the code seems to ask for? And that wasn't staff's interpretation of it. We were looking for an actual view shed as a public benefit.
So just let me make sure to clarify, both being new and making sure we're hearing what you're trying to express. You're saying that design as presented did not comply with the code of Fort Myers Beach as you understand it?
No, because what was being asked of us was to take a very small sliver that if you stood on one corner of one sidewalk would provide a clear view, and the rest of the clear view would have been satisfied through that tiny sliver above cars and below the building.
So you believe that view corridor is equal to any other component of the code? It's not a suggestion or alternative or recommendation. It's a code violation.
It's a requirement of the design, and they would have had to ask for deviations or variances to that specifically. For the view.
Oh boy, is that perplexing, because so then we're challenged with, would we rather have a 3-story building with no view through it, or this? Oh, I just don't know that's, boy. So I'm sorry, Jason, thank you for that explanation. Mr. Shaw, did you have other comment?
No, other than, like I said, the time is definitely
of course
an issue.
I understand that.
And again, this is their third basically design of which we came in with. Again, the original was a 3-story.
Come to
the microphone.
It was one building, but it was an L-shaped building, or excuse me, a V-shaped building. So it would span the property, but would not meet the criteria of the space on Estero Boulevard. It would not give that clear view. Was the issue.
So, Madam Chair, I think that there's a recognition amount the efforts you've all gone into to get to this point.
Yes.
There's a lot of sunk cost and effort and time, as you talked about. And while it doesn't appear here at the final, it's not like all the other things you suggested here are not good advantages, good improvements, and worthy, if you will, of protecting the effort put in that. I think that what you're hearing, to repeat what the gentleman said before, is we can't really visualize from what you've given us anything other than what we can see. And it looks scary in its architectural prominence. But if you have alternatives to take another stab at that piece and then push it back from Estero to the degree that variance needs to be asked for, requested, I think you have a lot more receptivity, at least on my side, to reacting to that in a more positive way.
So elevation, height, preferences is what we need to know. Again, I can't redesign something and then come back and say, just because we've taken and we're still at 7 stories or 8 stories height, that we're still got to be close to the road, because again, we've got to meet all these other criteria involved with it.
But Mr. Shaw, we're not in a position where we can say, here's what we'd like to see. It's not our role.
Yes.
I mean,
this does meet the criteria. This does meet the rules. And this, again, architecturally wise, no, it doesn't have the architectural drawings completed at this time. What we were requesting is really nothing more than what the zoning requires us to do. And we've met those criteria here, according to what I have seen.
But you've got 7 people telling you we don't like it. And what I'm afraid of, excuse me, you can't interact with the people who are speaking. You really can't. So I'm just going to tell you that I think your best bet at this moment, and this is a public hearing, so I'm going to open the public hearing, but I think your best bet is to ask to table this and come back to us. That's that person. Does anybody object to that?
No, I would say that something that the LPA has done recently, and I think I'm very pleased that we're going down this path, is having the renderings be something that is actually part of the package.
Exactly.
And by doing so, we can ensure that we're not just agreeing to the envelope, but we're agreeing to the project,
to the details,
to the aesthetics. So I don't think you're hearing a lot of pushback on the envelope, except for the setback on Estero. I haven't heard that up here. So I think your envelope seems to be, there's agreement, except for some variances required to push it back off of Estero. I don't know if that's clear enough direction.
Some architecture.
Yes.
Yeah, because what we would
what
we would like to be able to do is say that not only do we support the project, but that we have some assurance that the project will be built as it was presented.
Correct.
That's
Correct.
really what we're hoping for.
Correct.
So,
Don, were you saying something? I'm sorry.
Yeah, no, I'm just saying, I was just giving, thoughts or, you can stair step it back off of the stair to make it not such a, a tall, 8-story wall, and, there's other architectural approaches.
Right.
I'd love to, if we would do that, it'd be great if we could go to a time certain, August 13th, I think is.
That meeting has been changed, but before we do that, I'm going to open the public comment because this is a public hearing. So is there anybody, you have comments? Okay, go ahead, Amy.
I just have one signed up for comment.
Oh, just one.
Yep, Dave Lee.
Mr. Lee? Oh, hi, David. I'm looking at you. Yes, it's nice to see
My name
you.
is Dave Lay. I live at 1920 Bayview Drive. I'm a resident there, and I'm right across the street from this property. You'll know it because it's the one where the roof is ripped off my kitchen, and you can see right into my house. We're going to be rebuilding that house about 24 foot above ground. And the view down Palm Avenue, which I currently have, I want to at least make sure we maintain that. The view of the setbacks, it appears to be on these drawings, indicate almost that it's right up against the setback on the east side against Diamond Head, and it's right up against the setback on Estero Boulevard. This looks to me just like Madeira Beach, and I can't stand Madeira Beach condo rental complex one after the other. They all look exactly the same, and I thought we would never become that in Fort Myers Beach. That's part of the reason I'm here. I agree 100% with what Doug and Don said, that the idea of what Diamond Head did, even though they're kind of repulsive from the height and what caused the town to be created, is that there's a setback. It goes up 2 stories. They have all their offices and their convention rooms there. And then it steps back from there to the tall rise of the building. It seems to me you've got enough square footage to do that exactly on this property, but I can't at all go along with a property that's 106 feet tall, right on Estero Boulevard, and looking out the side. I mean, I might have a little sliver of view right down Palm Avenue, but I'm going to be seeing this huge complex. Part of the view that we like to see is the parasailers flying around out on the Gulf of Mexico. You don't have to look up terribly high to see that, and a property that's 3 or 4 stories high wouldn't block that view. So what I'm saying, they can almost build back what they had before, just make it higher. I mean, that's something that possibly could have worked. So again, I agree with Doug and Don about the fact that it should be set back. That's way too close, way too much massing right on Estero Boulevard, way too much. We don't want to be Madeira Beach. So,
Thank you, Dave.
Thank you.
Nice to see you. Is there anybody else who'd like to speak on this one? Anyone? Cash?
Cash is up in Fort Myers Beach again. Hello, everyone. I agree. I also agree. I think that the height is very scary, especially right on Estero Boulevard. That property, what was there before the storm, really did not take away from the views, and you were able to see through the beach. So when they say you couldn't really see through the property, I have to disagree. I grew up on Ohio Avenue almost my entire life. Jane was my neighbor for a very long time on Anchorage. So I have to say that if they can go to more of a 3-story concept, I think that fits our island a lot better. I mean, again, Diamond Head was created by the city of Fort Myers. We did not have input on that, and that's why we became a town. So to continue to build higher than that just doesn't make sense. I mean, this is the reason why we became a town. It's the reason why most people moved here, is because of the small island feel. If you want those big condos, there's tons of beaches up and down the coast of Fort Myers Beach that are Florida that will do exactly what you want. If you want that, go there. That's not what this town was. That's not what this town stands for. So I suggest smaller building, and if it is a wider footprint on their property, that's better long-term than having shade cast all day across the Estero Boulevard. Thank you.
Thank you. Is there anybody else who wants to comment? Okay, we'll close the public comment. Are there any further questions for the staff or for the applicant? Nancy or Amy, what is our August meeting date? Was it 20? It's the 20 something.
Give me just a moment, I'll find out for you.
Mm.
29.
Is that? Yeah. 29th, I thought.
That's what I have in my calendar.
You have it the 29th?
I do.
23rd.
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 What do I miss that?
Friday the 23rd. Okay, that's the August meeting, is Friday the 23rd. Would somebody like to make a motion?
Can the applicant provide revised application drawings by then?
Yeah, we could meet that. Mhm.
I'm going to make a motion to table.
Madam Chair, is it table or continue to a date certain? There's a difference.
Continue. I'm going to make a motion to continue DCI 120240015 to a date certain of August 23rd.
Second.
There's a motion and a second. Is there any discussion on the motion?
Madam Chair, is there any direction you want to give specific to the applicants as to
I think that's been our whole discussion.
Okay, all right, just
You need any other information? Yes, sir.
I have one question for you because I'm going to meet with them afterwards. Would it be something that you would like to consider where we put 2 different concepts in front of you?
Yes.
Again, without necessarily the beautification, because that costs a lot of money to have an architect come and take 2 engineer designs, but can we put the original design in front of you and then also make some changes to the current design and then have you tell it?
I would like that. Would
That'd be
you?
wonderful. Yeah.
Could
Yes.
we do that in some sort
already
of
done the work.
pre-planning meeting so that we don't
And
lose the
stop
August
this.
date as a hearing date?
You can meet with all of us individually, but you can't meet with us as a
Together.
group.
Okay, individually though.
Individually, you're welcome to meet with us.
Thank you.
Absolutely.
Can staff make that?
Jason, are you good with us taking this to the 23rd?
We'll make that.
Thank you, Jason. Okay. Is there any other discussion on the motion? Hearing none, my vote is yes. Jim?
Yes.
John?
Yes.
Doug?
Yes.
Don?
Yes.
Jane?
Yes.
Jim?
And I'm a yes.
Okay. Thank you all very much. For all those folks who I know are listening to this far and wide, just know that we're trying to help you out. Okay? Thank you all very much. We're going to take a short break. Okay.
How short?
10 minutes.
Thank you. So in Naples, every 2 hours, they take
figure out which Jason, you can just go in different
Yeah.
directions.
Okay,
Yeah,
if-
it was Jason said that, I didn't.
If everybody would please take a seat. I could please take a seat. Thank you.
The gavel.
Yeah, stab
The gavel.
The next item on our agenda is SEZ. Could you all please be quiet? SEZ 202-40126. This is for 74 Estero Boulevard. It's Leonardo Arms. A resolution of the Town Council of the Town of Fort Myers Beach approving with conditions or denying special exception SEZ 202-40126 to allow reconstruction of storm damaged infrastructure in the EC zoning district, including a partial parking lot, a new aluminum rail fence along the seawall, and a new fence with gate around the south garden for the property located at 7400 Estero Boulevard, providing for Scrivener's errors, severability, and effective date. Doug, do you have any ex parte? Doug?
No, ma'am.
Don, ex parte?
No ex parte.
Thank you. Jim?
None.
Jane?
None.
Jim?
None.
John?
None.
I have none as well. Eli, it's your turn. Presentation, please.
Oh, do I need to be sworn in?
Oh, you know what? I don't think we've ever qualified Eli as an expert. So Eli, tell us why you're an expert in your field.
Yes. Eli Lee for the record. I'm a planner with the town of Fort Myers Beach for about 3 years. Being a code officer for the town for 2 years, so a total of 5 years. And I got my master's degrees in public administration at FGCU.
And we're happy to have you.
Thank you.
So is that a motion to accept?
Yes, I'll make a motion to accept Levi Lee as as an expert in his field.
Second.
There's a motion and a second. Is there any objection to that motion? Okay, you're permanently an expert now. Go ahead with your presentation, sir.
Yeah. So, good morning, everyone. It's Eli Lee with Community Development. Leonardo Orange Beach Club Condominium Association has applied for a special exception to allow the replacement or repair of a major accessory structure that was constructed in the environmentally critical zoning district, and the construction of 2 new minor structures on the common element portion of the condominium property prior to Hurricane Ian. These previously existing structures is a partial parking lot. The main structures are an aluminum rail fence along the seawall and a fence with a gate around the soft garden. The applicant is requesting this special exception through the newly adopted ordinance amendment to section 34-652E that allows reconstruction or renewal of the primary structures and major accessory structures partially or fully within the EC zoning district, with the approval of a special exception. The EC zoning district is the land zero of the 1978 Coastal Construction Control Line. This condominium was constructed in 1969 prior to the creation of the 1978 CCCL. It appears that the parking lot was part of the pre-existing development prior to Hurricane Ian. The applicant is also proposing installation of the fences, which are new developments that did not exist prior to Hurricane Ian. Staff notes that because the proposed fences are new, they do not meet the code requirement for this special exception. Staff is available to answer any question that you may have. A representative of the Leonardo Orange Beach Club Association is here.
So Levi, you have recommended approval of the partially damaged parking lot, but denial of the new seawall or garden fence.
Correct.
Okay, thank you very much. Questions for staff? John?
Just a clarification, the reason that you're recommending denial is because they were not pre-existing and that they're new?
Correct. So the proposed new seawall fence as well as a soft garden fence did not exist prior to Hurricane Ian. Also, I know the applicant also stated there is supplemental that the proposal for the fence along the seawall was for safety purposes. And we have noted that in our staff report. I talked to the beneficial. The beneficial believes that since the seawall is not a walking surface, it's not required by the Florida Building Code.
Okay.
So that's what aided in my decision for denial of that request, as well as the soft garden fence as well. Part of the EC code section says that minor structures are allowed in the EC via special exception, but it must be relocated close to the landward edge of the EC zoning district, where these proposals are fully or mainly fully in the EC.
Thank you.
Thank you.
Thank you. Questions, Jim?
Not at this time.
Thank you. How about you, Jane?
I'll wait.
None here.
Doug, any questions for staff?
Yes. What is this? I've heard this reference to the safety fence seawall. What does this thing actually look like that they wanted to build? I didn't really see a good depiction of it.
It should be one of your exhibits.
When they say safety fence, is it like for a railing so somebody doesn't fall off the seawall?
If I may.
No, not yet. Just hold on.
So with the conversation, and the applicant is here as well, but with my conversation with the applicant, they're proposing, I believe, a 3 feet high fence on top of the seawall cap to help with anybody from climbing the seawall, crossing over to the other property, or jumping off and hurting themselves. They did state that it's going to be flood compliant, but the main purpose of it is to obviously for safety purposes.
Doug, the applicant is here and they evidently have something. So when they get up, we'll know what that is better. Okay.
One question,
yeah,
while
well,
I'm looking at pictures. On page 230 of the packet, there is a fence. Is that a garden fence? On 230 of the packet, I'm sorry. So here's the fence. Is that a garden fence?
It doesn't look like, I'm sorry, can you guys hear me?
Yep.
On the images that you guys are showing me, the garden fence that they're proposing is not in that same location. It appears to be across the site, in the same under the same common element, but not in the same location as what you're seeing on that image.
Okay. Don, do you have questions for Eli?
None right now.
All right. We'll invite the applicant up. Sorry, I know you were trying to be helpful.
Good morning, guys. My name is Miles Lagarde. I'm with South Shore Construction. I apologize that I'm here. One of the things about this property, and I know you guys have all gone through it.
Why are you apologizing that you're here?
Well, because none of the owners are here. They're still displaced.
Oh, of
they're
course
hoping
they are.
within 2 weeks they'll have property back to their
Sure.
the
We
power back to their
understand
property.
that.
So I've worked a lot with them, and they're all just fantastic people.
Sir, may I interrupt? Have you been sworn in?
Yes.
Thank you.
Oh, cool. Okay.
Does he need to be an expert?
He's just.
A couple of things that I wanted to address. This has been quite a process. I think we started out with 7 pages, and I think you guys are well into 50, 60 pages. This thing just keeps kind of reinventing itself. And when it first was proposed, it was for the entire parking lot. And then we realized, hey, we just need to keep this down to anything that is seaward of the CCCL. So it's kind of really shrunk. So one of the things was we removed all the parking lot lights. They did get accepted as a grant, so there'll be none in the CCCL area, but they were, again, approved for a grant. So anything in that immediate area will be taken care of with the Turtle Conservatory. The couple of things that Eli had mentioned, I guess I'll jump to the main thing, is the fence that they're trying to propose.
Doug, look, pay attention to this. Here's the fence.
Is what's really tricky is it is going to be proposed on the seawall, and you should have a site plan that shows that. The tricky part is there was no seawall prior to Ian, so this is a new area for them. Until the beach replenishment is done, the only way to get from Bermuda Dunes across Leonardo Arms into the next property is the seawall. So they just don't want people crawling on the seawall and walking across the seawall to get through the property. That's the idea of the safety gate. The other thing is part of this proposed parking lot replenishment. It's not in here because it's gone separately. Is on top of the seawall, they're proposing a rock apron that actually is shown in your survey that is under permitting through this the state. And that's another thing. They don't want people walking across the seawall and possibly falling into the rock apron. So it really is a safety concern. Obviously, it's probably not very pretty, but it'll be up to code, powder coated, and they just feel this is a safety feature. This is why they wanted to have this gate or this fence on the seawall.
Hold on one second.
Sure.
Does that change your opinion?
I wrestled with it for a little bit.
Yeah, but it's the rocks, right?
It's the
I know the Ross you're talking about is the riprap, I believe,
yeah.
on the waterward. So yes, I do understand that the argument that the Miles was making during the whole review process was obviously that, you know, fall protection, things like that. When I talked to the beneficial, he said the Florida Building Code does not require it because the seawall itself, the intent was it is not a walking surface, so there's no need for it. So that's why my staff report I recommend deny it, because it's not recommended by any Florida Building Code or fire code or anything like that. It's more so of a liability purpose, I would say.
Okay.
The only thing I would say to that is again, and my last point on that is the seawall starts at only about 18 inches high. And as it goes across the property, it grows. So although the seawall is not a walkable surface, it is 18 to 24 inches wide. That's easily accessible to get on.
People walk on sea.
Yeah. And again, to get across the property, that's where they're going. So I guess I don't want to take up a lot of time. That's my thought on that. As far as the south garden fence, Eli is correct. It is part of their south garden. They're just asking to relocate that. The reason why they're asking to relocate that is I was here about 8 months ago for a special exception for the pool. And part of us getting the special exception was agreeing to, without identifying exactly, to get rid of what they had was a knee wall that went back across that property. And then we agreed to plant native plants and things behind the building. So what the gate was partially there for, they're basically giving part of their garden back, and they're asking to keep it on the side of the building. Again, you'll see it on your survey. So they do want to keep a little bit of the small south garden, but it'll be on the side elevation of the building as opposed to behind the building. That will all be replanted with native plants and stuff like that. So that takes care of those two. And then the parking lot is very crucial to them. The building, Leonardo Arms, was built in the early 70s. So that was far, years before the 1978 CCCL, and the parking lots are deeded to the building and to the owners. If you take away the 14 to 15 parking spots that they're asking to get back, the building as is falls 30 parking lots shy of today's code. If the building were to be put back tomorrow, it's required to have 90 spots. At best, it's only going to have 60. So they can't afford to lose those parking spots.
Good presentation.
Very well done.
Thank you.
Thank you, Miles. Any questions for the applicant? Let me just, Doug, are you clear on the fence now?
Yeah, and if I may comment, I think the fence or some type of fence there, and I think when you do have a fence, probably needs to be 42 inches high, but is probably a good idea, even if it is a build back. If they're going to put the seawall in, I can see a potential hazard. Even if it's, it's not supposed to be a walking surface, but kids and stuff, people are going to probably walk there. So I would say the fence is I would go along with the fence. The garden gate, I'll let somebody else comment. I'm just not sure.
Okay, thank you, Doug.
But the fence, I think, yeah.
Thank you. Don, any comments? No. Jim, comments?
I think it's pretty obvious to me after hearing the presentation, the applicant's trying to do the right thing for the right reasons with your own money, and you don't have to do them. So I think it's advantageous to both how the development will end up being utilized, protected, and I get the liability piece. So good job.
Thank you.
Thank you. Jane, questions?
Ditto on Jim's comments.
Jim?
I'm not sure I understand what the benefit of the gate and the fence is when the property to the south is wide open. It looks like somebody from Riviera Club can just walk in there anyway.
So yes, and I guess my only rebuttal to that is, like I said, until the beach replenishment happens at high tide, there really is not much of a beach to walk on. So they're going to walk on that seawall, and the seawall was not there prior to the storm.
I'm not on the seawall.
You're on the other side.
I'm on the fence for the south garden. It looks like you're blocking off your own residence when anybody coming from the south has total access to it.
So there is an old property wall, small property wall that I guess wasn't highlighted that's still in place. So it would kind of, by running the south garden fence like that, it will just encapsulate a small little garden for them.
And what's the intent on, I guess, enclosing this?
Just because they gave up all the property willingly behind the building, they just want to move the garden of whatever they had there into a little separate area, I guess is the best way I can explain that. Right, wrong, or indifferent.
I mean, they can have the garden. This is a fence issue.
It's just so people tromp through it. Like I said, if there is a small retaining wall, property wall that's still in place, on the other side of that, the property that you're referring to just put in a tiki hut. So there's going to be some loud noise. There'll be some partying there, or whatever they do, which is, again, not a big deal. It's just a little enclosure for them to, and that was specifically required or requested for me to ask. So other than telling you that they just want a little piece of tranquility, that's the best I can tell you.
Okay.
John, any questions?
I think the seawall fence is a brilliant idea, actually.
Okay. Any objections to the garden fence?
Not particularly.
Jim's the only one with the garden fence issue.
Yep.
You have a lot of fake plants in your house, don't you, Jim?
No, he's a landscaper. He's a plant guy. That was a bad call. That was a bad call, Miles.
If that's going to hang me, then I got a long
All
way
right.
to go.
Okay. Any other questions for the applicant?
Nope.
Thank you very much, Miles.
Thank you guys for your time. I really appreciate
we
it.
appreciate you. Okay, we'll open it up to public comment. Does anybody have any comments on Leonardo Arms? Okay, we'll close the public comment. Any further questions for staff or the applicant?
Nope.
Anyone? Okay. May I have a motion, please? Or would you like to take them individually, or would somebody like to make an all-in-one?
I would like the aluminum gate and fence on the south garden to be a separate consideration or vote from the fence on.
Well, let's take them individually. Let's take them all individually. May I have a motion to approve the replacement of the partially damaged parking lot?
So moved.
Thank you, Jim. Is there a second?
Second.
There's a motion and a second. Is there any discussion on this motion? Roll call. Jim? Yes?
Aye, yes.
Jim?
Yes.
John?
Yes.
I'm yes.
Yes.
Jane? Doug?
Yes.
And Don?
Yes.
Okay, now how about the seawall fence? May I have a motion there?
I'd like to motion
I would.
approve the
Go ahead.
seawall.
Okay,
Fence.
Jane's made a motion to approve. Do you second that, Doug?
Yes.
All right. Is there any discussion on that? Your motion, Jane? Your vote, Jane?
Aye.
Doug?
Aye.
Don?
Aye.
Jim?
Aye.
Jim?
Yes.
John?
Aye.
Yes. Unanimous. And now, Jim, did you want to make a motion for the garden fence? Or do you want some discussion
I have
on the
one
garden
question
fence?
on the garden, yeah. Okay, so is this, my question is, this, oh shoot, sorry.
Reason for denial if I deny it.
Is this fence right here the old fence, and is this fence going to go across here and block it, or where does this fence go?
Or maybe it's better if you guys be the applicant.
Okay,
Who are you asking, Eli or the applicant?
anybody that can answer it.
What page are you on, Jane?
I'm on page 230 of the packet.
230.
That's the picture.
Oh, yeah, sure. Have at it, Ben.
This one?
Fire away.
So there is a walkway closer to the building that appears to go in the front of,
So from the
Riviera.
parking lot, there'll be a walkway here of pavers that they have that are landward of the CCCL. This is where they would like the gate. And then this is just the area that I have here that's going to end up being, thank you, that'll end up being the garden.
Yeah.
that's directly in front of the pool, close up to the pool, not in the walkway coming over from Riviera Club to walk in front of Leonardo Arms.
So That actually is not anywhere near the pool. I'm so sorry. I know it's hard to see. So from Leonardo Arms, their pool is way over
Okay,
here.
sorry.
That's okay.
I was
So it's basically
seeing those
off the front of the
cross
parking lot to the left of building 1 is they just want a little bit of a garden area.
And building 1 is the one closest to the water, correct? Where the damage is for the parking?
No, so building 1 is not damaged with the parking lot at all.
It's at the other end.
It's at
It's
the
on the
completely
south
other end of the building, the south end of the property,
Over
yes.
there. So it's not going to cross the path that comes from the south end building to walk north?
Correct, it will not.
Okay.
It's right here.
Okay, okay. I don't have a problem with that. I just didn't want the walkway crossed off.
Oh, yeah, I could.
Jane, you see, did you have this one? Yeah. This building is next to Riviera.
Right. So now I understand. I just was not seeing the location of it properly.
Would somebody make a motion on this famous gate?
I'll move approval, Madam Chair.
You're moving approval.
I'll second.
And a second by Jane. Any discussion on this? You want to make your pitch again for no gate?
No,
Okay,
I don't see the purpose.
okay. There's a motion and a second. Is there any further discussion? Your vote, Jim?
Yes.
Jane?
Yes.
How about you, Doug?
Yes.
Don?
Yes.
Jim?
No.
John?
Yes.
I'm yes also. Okay, so I don't see any purpose either, but they're asking, so it's all right with me. Motion carries unanimously. Good luck and.
No.
Oh, the motion, that's right. That's right. We have a dissenter. Jim, the dissenter.
Town council.
All right.
Bring more gardens.
Next item
Yeah, don't
is,
bring gardens
Don't bring your
to us.
gardens back.
the next item is, this is all variances. So this will be a final action because we'll decide this unless anybody objects in the next 10 days.
And your decision is unanimous.
And it has to, oh, that's right. And it has to be unanimous. Oh, we'll see. Okay. VAR 202-40071. This is 1250 Estero Boulevard, Cottage and Shuckers. A resolution of the Town Council of the Town of Fort Myers Beach, Florida, approving with conditions VAR 202-471, 5 variances from from LDC sections 34-674A1B, 34-675B3, 34-676A4, 34-676B, and 3467D, requesting relief from build 2 line maximum setbacks, increased building height, parking reductions, relief from parking location, and location of site access in the downtown zoning district. For the property located at 1250 Estero Boulevard, less any area within the EC zoning district, generally known as strap number 194624W40070F.0010 to redevelop a restaurant bar and providing an effective date. Jason.
Jason Smalley with your Planning and Zoning Department. As was mentioned, the request before you revolves around 5 separate variances for the redevelopment of a previously existing restaurant and bar. The previously existing building was generally known as Cottages and Shuckers, so that will be returning. The buildings originally were constructed in 1921. Over the decades and years, they have expanded. And as of the introduction of the 1978 line, a large portion of the building complexes ended up on the seaward side of the 1978 line. So after the storm, the complex of buildings was effectively completely destroyed. It's been demolished and the site has been scraped since. And the applicant is coming back to try and redevelop the uses as they existed pre-storm. Now, the 5 requests before you, I'd like to put into 2 separate buckets. There's one bucket of requests that are generally to keep the site as it existed pre-storm. And there are 2 requests of the 5 that are functionally different. And those include an addition or a request to have additional height over what would be allowed for this zone. The requests themselves, again, generally are to keep the site as is. We'll go through them briefly here. One of the requests is to deviate from the requirement of a build to line of 0 to 5 feet. As we talked about in the previous timeshare, that is required by code. They're asking for a deviation to that. The current building, I believe, the building pre-storm existed, I believe, somewhere between about 46 to 50 feet back from Estero. They're looking to rebuild generally that same placement, but they're going to pull all of those buildings forward of the 1978 line. So that first deviation is to effectively not have them right on Estero. The second deviation request is the increase in maximum height. They are requesting 2 feet 3 inches. Staff can state that for the most part, that additional height is going towards redeveloping the final destination of the elevator shaft on the top of the building, where they would access some storage and office space, and that would also be the access to the roof for their mechanicals and electricals. The third deviation being requested is a reduction of the parking. So staff recognizes that the parking that existed before was not compliant. The site itself, the new request is requesting to remove a vast majority of the parking on site. I believe the number to be reduced is 97 spaces. So they will be providing essentially the spaces that existed there pre-storm on the site. I would note that this is what staff considers to be a flag lot. So it's generally sort of L-shaped in nature. And the parking that existed pre-storm will be retained in the pole of that flag lot directly adjacent to Estero. So they will be taking access from Estero through the lot, and that's where the parking is intended to remain. The fourth request here is a deviation from the requirement to develop parking on site in the rear, or in some cases to the side of the building. Again, staff recognizes that the site is, they're bringing the buildings forward to the CCCL line. There really isn't a way of putting parking in the rear. That would therefore be waterward of the line. And this is in conjunction with their request to keep their roughly 45-foot setback from Estero rather than pulling it forward. Lastly, their fifth deviation request is relief from the requirement that you, when redeveloping a site, that you close off the curb cuts and entrances off of Estero and instead relocate those to side streets. They do have access to a side street, but the way that the lot is designed and the relative closeness of the property lines, it is a relatively thin lot. Staff understands the request to keep the entrance on Estero where it is and then allow for ingress and egress on the side street as well. Staff is, one last thing, the difference here is roughly 1,100 square feet in the area that is being requested compared to what existed before storm. Staff also recognizes that much of that deviation is going to come from bringing it up to flood codes, making it ADA compliant, but that number is roughly 1,100 square foot difference, an increase of 1,100 square feet. Staff is here for any questions or comments that you may have, and the applicant and their representative are here as well.
Thank you, Jason. Is Don gone? Don appears to be gone, so let the record reflect that Mr. Sudduth has.
He's there.
Oh, he's back. Never mind. No.
I sneezed and forgot to turn my camera back on.
Very tricky there, Mr. Sudduth. Okay. Any questions for Jason? Don, do you have any questions for Jason?
No question.
How about you, Doug?
No, ma'am.
Jim?
Nope, very clear. Thank you, Jason.
Jane?
Nothing right now.
Jim?
No questions.
John?
I'm good.
Thank you very much, Jason.
Madam Chair, were there conditions associated?
Yes, thank you very much. So There are some conditions here that staff has recommended. A couple of them are generally going to be boilerplate, but we did want to make the point that if the deviation with regards to further reduction of the parking counts were not approved, that the applicant would need to come through prior to getting any permits and show us that they can provide the full count of parking on that site, which would mean the full 114, I believe, parking spaces that would be necessary under today's parking counts.
Thank you very much, Jason.
You're welcome.
Okay, the applicant.
Good afternoon.
Good afternoon.
Thank you, Madam Chair. Good to see you all again. Noel Davies on behalf of the
Nice to see you too.
Just a quick housekeeping item, and I may have missed it. Did we do ex parte on this item?
We did.
Okay.
Do you need to run through it again? I don't think anybody.
Nope. I just wanted to make sure that was a record.
We didn't do ex parte because it was.
Okay, well, let's do it. Let's do it
All
for
right,
the record.
we will. How about you, John?
Yes, actually, I've met with the neighborhood group
Uh-huh.
on this project.
Jim?
Same.
Same. Jane?
None.
How about you, Doug or Don? Ex parte? Did you meet with
No, ma'am.
Patrick?
I did.
Uh-huh.
Oh, wait, I did meet with him
Yes, you
here
did.
at the building. I'm
Yep.
sorry.
Doug,
Brain dead.
did you say yes?
No, I did not.
Okay.
No ex parte.
Okay.
Thank you very much for reminding about that.
Thank you.
About that. Yes,
Again,
go ahead.
Noel Davies with law firm of Davies Duke on behalf of the applicant, Right Choice Investments LLC. The project team is here today, including Joe Orlandini, as well as the applicant's professional planner, Patrick Finesse with the neighborhood company. Our request today is to seek your help to build back the iconic cottage. In order to do that, as you heard from Mr. Smalley, we are in need of 5 variances. The shape of the subject lot is unique, as you heard from Mr. Smalley, and given the updates to the FEMA regulations, as well as that 1978 coastal construction control line, these variances are required to, in essence, build back what was there before Ian. And with that, I will turn it over to Mr. Vanass to walk you through the specifics of the variances, and we'll both be here for any questions you have.
Thank you, Mr. Davies.
Thank you, Madam Chair.
Welcome, Patrick.
Good afternoon. I'm pretty excited to be here today. For the record, Patrick Vanass, certified planner with the neighborhood company. You guys were talking about a famous fence. We are going to talk about a famous venue here. The cottage, Shuckers. I know we've all been there. It's very close to my heart. And was one of my favorite places on Fort Myers Beach.
Mine too.
And I think we all agree it's iconic. We want to see it come back. So we are going to talk about the world famous cottage and Shuckers.
Okay.
Okay. I'm missing something here. Okay, so what I'm going to do today is I'm going to give you a little history, a little background on the venue, and I'm going to talk about what's being planned for the future of this property and the uses that they are requesting. And I'm going to walk you through the variances and why those variances are justified. So just to give you a little history though, before we start this, the venue was first developed in 1921. It was a casino. It was the Crescent Beach Casino when it first opened. Over the years, they added some rooms in the 30s and 40s, and it became the Gulf Shore Inn. It was also a bathhouse. And I don't know about you guys, but I always wonder what's a bathhouse?
I think it meant something different.
Yeah.
Back then. It has meant.
But it was the Gulf Shore Inn and Bathhouse, and it continued to evolve through the years, and it became a very popular restaurant and bar venue. And in the 80s, the cottage opened, and it became the venue that we all grew to love. The cottage, the Shuckers, bar, restaurant, pub food, live music, entertainment. So Obviously the hurricane wiped it out completely. So in order to come forward and redevelop, we do need to ask for these 5 variances that staff introduced. Just a little background about, a little context about the property. It's one parcel, a little under an acre, plus or minus 0.82 acres. It is in the pedestrian commercial future land use category. That's the development area of the property. The beach area is within the recreation future land use category. The existing zoning is downtown, again, for the development area, environmentally critical for the beach area. As we know, previous uses have been wiped out, and we are coming forward with a new proposal. Location, I'm sure you guys all know where that is, but about a quarter of a mile from the base of the bridge. And as you can see on this exhibit, the property is a flag lot. It's irregular in shape, and we got a close up here. And the lot is about 50 feet wide along Estero. Midpoint lot, it goes to about 100 feet, and that's at the widest point on the beach. We're at about 152 feet. What's really important to point out on this aerial is the 1978 coastal construction line. And as you'll see, pretty much all the variances that we're asking for stem from having to deal with this 1978 coastal construction line. What you can see is that most of the building was seaward of that CCCL. We now have to rebuild, and everything has to be landward of the CCCL. And the challenge with that is we're dealing with a much narrower portion of the property. And also we are having to eat into existing area that was used for parking. So we're going to address that and talk about that. And, essentially the widest part of our property is now going to be left open and beach without any structures on there. This is just a different view of the property. Again, it's just to show you pre-Ian conditions. Most of the structure within the widest part of the property, and then post Ian where it was completely wiped out. As mentioned by staff, the previous structure there was plus or minus 11,000 square feet. We are asking for 12,000 square feet. And I'll walk you through the floor plan so you get a real appreciation as to how things have changed. Everybody that's been there will remember the bathroom conditions at Cottage and Chuckers. Well, you'll be very pleased to see. Yes, you'll be very pleased to see that we have much bigger bathrooms, bigger kitchens, bigger back of the house to just make it a much more modern, functional facility. The actual patron space that was usable for the guests and diners and people at the bar is staying roughly the same. We couldn't get an exact count of what it was before, and even the property appraiser records are very general, but that number was probably somewhere between 7,000 and 8,000 square feet of usable space. And what we're asking for today is 7,800 plus or minus usable space. So staying about the same, the extra square footage really for back of the house. So the concept for this new venue is going to honor the history of what was there. The ground level will be a beach bar. The intent, just like it was, you go to the bar, you can be there in your flip-flops or bare feet, and you can walk right onto our sandy beaches. The second floor is going to be the restaurant part, Shuckers, and that'll be fully enclosed, casual fine dining, and it'll be a restaurant and with a bar component to it for people waiting to be seated or just people that want to eat at the bar. The third floor will be the cottage. That'll be a little more open air. It'll be more of the pub food type of dining up there, and it'll be the bar and entertainment venue with live bands and music for the cottage. As mentioned, the building is different. It's got to be built a lot stronger. It's got to be hardened. It's got to be a resilient structure. It's got to meet all modern codes. And when I'm talking about codes, we're talking about Florida Building Code. We're talking about FEMA requirements. We're also talking about code, Fort Myers Beach codes that have changed over time. So keep in mind that these structures and what was there previously were all legal buildings. Those were built at a time where the rules were very different, but they built them legally. And what's happened is over time, we keep changing codes and we keep making things a little more stringent, and rightly so. We are in Florida. We do have hurricanes, but when something gets destroyed, we have to address it and we have to build it a little differently. Hence the need for these variances. So again, why, and this is criteria that is in the code that we have to address when we come forward with a variance. So why are we asking for this? Well, obviously it's the hurricane, first of all. Second of all is we have to meet current code requirements. And third of all is we want to build back a beach venue like it was. This iconic venue was always a beach bar and restaurant that you could walk right onto the sand. And we want to keep it that way. So those are the reasons why. Question is, are we going to have a negative impact on surrounding properties? And my professional planning opinion is that no, there will not be any negative impacts. Again, we're putting back something that already existed. And from a hardship standpoint, I mentioned it's really a question of we've been through a devastating hurricane. We've got a funky, irregular lot that is unique, and we have to meet today's code requirements. So these are the 5 variances. Before I go into that, I'll just show you what's being proposed. This is a rendering of the front of the proposed cottage. It's going to have a contemporary coastal architecture. And again, we see the various levels. Lower level is going to be the beach bar directly onto the sand. Second level is going to be enclosed and is going to be AC for the restaurant. Upper level will be the cottage. And just on the rooftop is where we have our mechanicals, AC, elevator shaft, fire suppression type of mechanicals. This is a view from the rear of the property from the beach. Again, just showing you that the rear is a little more open. That's where you've got the open views of the water, direct access onto the beach. This, again, more of a close-up view, and I think that really shows you the look and feel that is desired here. And again, keeping this, different look, different style, more contemporary, but the same vibe, the same beach bar that we've grown to know and love. These are just the architecturals, front, rear, and these are the floor plans. So what you'll see, this is the ground level. I just want to point out on the lower right side, that's where the entrance is, reception, there's some seating area. All that area is area that didn't exist before. You're going to have a stairwell. You're going to have an elevator shaft. There's a secondary stairwell if you look on the upper left corner. Any kind of recycling and garbage is going to be enclosed fully with roll-up doors. They're going to be brought out on collection days, and you're going to have some dry storage there. Long linear bar, very reminiscent of what was there before. Second story, same thing, a lot of back of the house area. As you can see, a much bigger kitchen than they had before, and modern, up-to-date bathroom facilities to make it easier on all of us. And on the upper floor, same thing, stairwells, office space, much bigger bathroom facilities. They kept the bar very consistent with the old cottage bar, and I'm looking forward to seeing it built and having those memories of the old cottage. So this is just the upper the upper deck, and where the fire equipment is and the elevator shaft. So I'll go through these variances one by one. The first variance is associated with the building placement. As you know, this is in the downtown district. The intent of the Build 2 line was really to activate the public realm and put some storefronts like you see in a lot of towns, a lot of downtowns near the street. I think we all recognize that this is not retail, this is not storefront. It's an iconic bar that was always a beach bar, and we're putting it back along the beach as close as we can to the beach. So it straddles the coastal construction line, and we are asking for a 34-foot setback from Estero rather than the 5-foot Build 2 line. The next deviation is the height variance, and we are allowed 40 feet above design flood elevation. We are asking for a height of 42 feet and 3 inches. And that additional height is really to hide the mechanicals. And if it wasn't for that height variance, I think we would have a building that just wasn't as attractive, where you could see some of those mechanicals on the rooftop. The third variance is the parking requirement. As Jason mentioned, we were deficient prior to the storm. There were 28 parking spaces on site. Today's code requires 114 parking spaces. And unfortunately, with the new placement of the building, we lose 10 parking spaces. Actually, 12. I'll explain that to you. We are providing 18 spaces, but 16 of those are actual spaces. 2 of those are credits for bike racks, proposing 2 bike racks. We understand this is a significant reduction in parking. However, as was discussed with the whale that came before you a little while back, this is the best we can do on this site. There is no other room for parking. And I think we, as a town, are acknowledging that in the downtown district, we have to look at parking a little differently. And we believe that the solution for the cottage and some other venues in the downtown area is paid parking. And in a quarter mile from this property, there are over 550 paid parking spaces. The next variance requested is the parking lot location. Again, with this idea of bringing the buildings up to the street. The idea was to put the parking in the back. We're not bringing the building up the street. Therefore, we need that variance. And last but not least, we are asking for a deviation to keep access to the property along Estero. What the code calls for is if you are located along a side street like Avenue A, the code intended on the side street becoming your primary access point. In this case, we don't think it's a good idea because it just isn't feasible from a functionality standpoint. If we took access from Avenue A, you would have to go into the parking lot and somehow turn around because you can exit on the Estero. There's not enough width to have a two-way drive aisle in there. Also, Avenue A, as staff mentions in their report, is used quite a bit by beachgoers. So again, if we can minimize and just have an egress situation along Avenue A, we think is a better situation. So with that said, I will just quickly go through some of the criteria. I'm not going to deal with each variance one by one, but I do want to talk about the boxes that you have to check off when you approve these variances. And first one is whether there are exceptional or extraordinary conditions or circumstances associated with this property. As mentioned, we've had a devastating storm. It was an act of God. There is also a very irregular shape to this property. And also we have a coastal construction line that has changed over time and has significantly reduced the ability to develop on the property. Then criteria number 2, those exceptional or extraordinary conditions, were they caused by an action of the applicant? Again, no, the property has always been irregular and the storm was not caused by the applicant. Whether the requested variance is the minimum variance to allow this use, the answer is yes. We are keeping the same uses, and we are keeping roughly the same square footage total, slightly bigger to accommodate for these mechanicals and back of the house functional requirements. But from a footprint standpoint, the footprint is actually smaller than it used to be. Then the next one is, will granting the variance be injurious or detrimental to neighbors and the public? The answer again is no. We are putting back an existing use, and we think that it fits within the context of the downtown and historically the uses that have been there. And last but not least, is this a reoccurring variance that somehow would need a code change? No, this is very unique to this specific property and specific conditions there. So with that said, in my professional opinion, I think we've met all the criteria. I think we are consistent with the code and the comp plan. And I do want to make one request. I know that you mentioned that your decision can be a final decision, and that if it's unanimous, there's no need to go to council. We were hoping to be at the LPA last month. We had to be at the LPA today instead. We're trying to get final approval before the July break. So given that the next meeting is on the 17th, if someone waits to the very last day to put in to contest this, we would then get bumped to August. We want to keep our time scheduled for the 17th at council. We will go back there and talk to council if needed. If no one files a complaint, then we are fine, but we want to reserve that spot on the agenda if needed.
Did you hear that, Amy? Okay.
Okay. So thank you very much for your time, and we are here to answer any questions you may have.
Thank you very much, Patrick. Questions for Patrick? Let's start with you, John.
No, it's very thorough. Thank you.
Anything from you, Jim?
No questions.
Jane?
With the third floor being where the live entertainment is and is most open on both sides, how do you plan to contain the noise from going back towards Estero Boulevard?
I'm glad you brought it up, and we knew in our discussion that this might come up. Part of it is I'll take the blame for this. These plans call for roll-up shutters at the ground level, and also for the cottage up there. We never indicated that in our application, but through the discussions, and I sat down with Joe also, and we talked about how this could be addressed if there was any kind of sound concern. Joe has indicated that they want to look into putting garage doors. So I think the option is either roll up shutters or clear glass garage doors that could be closed down if there is live music past 10 o'clock, but they fully intend on abiding by the noise ordinance and also having a mechanism to contain that noise. And the other thing also, and we've discussed this for other cases, is this would be fully directed towards the beach. There's going to be building behind them, and that will buffer and direct the sound where you don't have people.
Can you go back to the view from the Estero Boulevard rear? Yeah. So all of that looks like it's open to me.
So what you're seeing on the right side is really the stairwell component of it. And there's like one bay that is open, but same thing, the treatment would be the same for that bay as it is on the Gulf side. There would be either a roll down shutter or some kind of a garage door that can be open or closed. But the idea and the discussion that we had was, when they designed this, they were trying to honor the old cottage that was an open venue, but understanding the concern for the sound, the applicant is more than willing to put those garage doors in there. And also what it does, it does protect patrons or the facility itself from the weather.
So there could be an additional condition that
Right.
adds something to do with closures.
Because we required the Beached Whale to have all of their live entertainment be enclosed. Is that not correct?
I did look at the approved ordinance for the beach whale, and I did look at the minutes of approval. Council approved it without any conditions.
Yeah.
However, I know that the owners of the whale had just made that commitment, and they had indicated that to everybody that the venue was going to be enclosed, and all the bands and the music would be internal.
Anything else, Jane?
That would be my only concern, because noise violations are the biggest thing we talk about on this beach. And to have that open to the Estero Boulevard side, I think will create a never-ending issue of where's the music coming from.
Okay.
Jane, I've got Joe here, and he's nodding, and he's okay with making that commitment today. Yeah.
Okay. Jim, any questions?
No, nothing.
Don, any questions? Doug, any questions?
There's Don.
There's Don. Any questions?
No questions.
How about Doug? Is he around?
Not
We lost Doug. I think.
Arizona?
Okay, we'll assume that Doug doesn't have any questions either. Thank you very much, Patrick. Appreciate it.
I don't see him on the screen.
Yeah, he's
I
not.
think we lost.
He's not.
Okay.
Okay. Any other questions for the staff or the applicant? Or any discussion on this?
Well, I think that the height being to cover up the mechanicals, it doesn't appear that their ceiling heights are extreme to make it, worth having it be 2.5 feet shorter. I don't really have a problem with that. My only problem, like I said, would be adding that condition to that.
Well, I'll tell you what, because I'm very excited about this project. I'm going to make a motion to approve.
We need public comment.
Oh, gosh darn it. Well, I'm still going to make the motion when we come back. Thank you, Jim. I apologize for that. Does anybody want to make some public comment on this? Hearing none. Hearing none. Mike, are you going to come up? Thank you.
She's just videoing. Or is she?
I think she's just videoing.
Okay.
We're wondering if she's raising her
Is
hand
she
or
raising her
videoing.
hand or?
Oh, no.
Okay.
She's videotaping. Go ahead, Mike.
Yep. My name's Mike Miller, owner of the Beached Whale. I want to go on record that I am 100% for the cottage. We're reopening up. I hope you guys approve it. My only concern is the noise. I don't want to be
Only guy
the
that's
brunt
being-
of all of any complaints. And the reason is because, I have completely enclosed and spent hundreds of thousands of dollars in a soundproof, for the most part, second level. And, having that dance floor on the third floor, it's going to be awesome for the cottage. It's going to be exciting. Anyone that complains in the residences behind me, if they hear it, they're going to think it's us. And I want to just see a plan where it's going to be enclosed and more soundproof. Give you one example, and then I'll be done. Is one day we got a complaint that we had our music was too loud. And this is while we were under a tent. Okay, and I understand perfectly. We called the gentleman back the next morning and let him know that we weren't even open, and it was the taco company, Yo Taco, and they had two speakers facing Estero Boulevard jamming music. And it was loud enough where we got a complaint. And again, I'm all for 100% for the cottage to open. I hope you guys all do it unanimous and things start breaking ground as soon, right after us. And we break ground in a couple of weeks, and and get the ball rolling and get this town back together. But I just want to make sure that, and that's a concern, and Jane had mentioned it, just figure out something to be able to enclose that so we don't get the grunt of the complaints. So that's it.
Thank you for your comments, Mike.
And good luck, cottage.
Thank you very much. Is there anybody else that would like to make any comments? Okay, we'll close the public comment. And, I didn't mean to jump to is there any other discussion on this?
I think that we do need to discuss that condition, because not only maybe that it needs the walls in the back, but it needs to contain its music on its property, on the sides and everywhere else, so that, it isn't traveling.
It's not traveling anywhere?
Well,
I mean, because I think asking them to have that be a completely enclosed area eliminates the idea of it being the cottage bar.
I'm asking them to be responsible for their noise.
And that would be their responsibility, period.
Right.
And there are decibel requirements
Absolutely.
anyway, so those protect us, and we don't.
Yeah.
Can't be more restrictive than those.
Okay, well, with your permission, I'm going to make a motion to approve the variances for 1250 Estero Boulevard, which is the cottage and Shuckers, including the findings and conditions of approval in the staff report, adding a condition that there be enclosures on the third floor to contain sound as much as possible, and finding that this is consistent with our comprehensive plan.
Fully support.
Second.
So there's a motion and a second. Is there any further discussion? My vote is yes. Jim?
Yes.
Jane?
Yes.
Doug?
Yes.
Don?
Yes.
Jim?
Yes. Yes.
John? Congratulations. Thank you for